All right, I think we are all set. Good morning, Ms. Fisher. Can you hear us?
Good morning, Judge. I can, yes.
Fantastic. Thank you for joining us and helping out today. I will let you know when something needs to be taken down. I'm going to be calling a calendar and we may have some discussions about the cases, but I'll let you know what position and when we need something taken down.
Perfect. Thank you.
You bet. So we've got a final plea calendar to call this morning. Any case, every case on the calendar is, if not resolved today, rolling over to the March trial calendar that is being called on March 12th. So it's 1 month and 2 days away if we don't resolve the cases today. Position 1, and I think it's also position 14 on the calendar, is Kyrie Rhodes. All right. We don't have a Mr. Jerome. Any word from anyone about having heard from Mr. Jerome?
No, Your Honor.
Okay, we'll reach out to his office to see what's going on there. But Mr. Rhodes is here?
Yes.
Okay. All right, see what we can find out from his office. Mr. Felker is online at Baldwin State Prison. Is Ms. Wood online?
Yes. Oh, here.
Dun, dun, dun. Wow, that's pretty impressive. All right, why don't you get situated and we will cycle back to that. We'll skip 2 and 3. We'll go to number 4, Jared Milam.
Your Honor, I have not been able to get in touch with him as of late. I'm hoping I can put it in touch with his family. The offer has been a diversion offer. I'm sure he would take it,
But we need to find him first. Okay. Ms. Smith, we'll do bench warrant unless Mr. Milam lets us know that he is on the call or here in a little bit. All right? Manuel Salvador Casillas.
We're holding for his attorney.
All right. Is Ms. Nix on the call or is she coming this way? We'll see, but defense attorney's not here either. Is anyone here for Jerry Diggs? Christopher Campbell is retained counsel?
Yes, Judge, this was my case and yes, they
Okay.
hired. Let's go.
And he's on trial. I do believe I have to double check his.
Okay, Mr. Diggs had to leave. He was brought over and then something came up and he had to go to medical, so he's not here. I'm curious, although we need Ms. Nix again, if we can, if it hasn't been dismissed, if the older case can be dismissed. I think it got re-indicted. Let's look. Yeah, it's still open, but that's a Ms. Nix question. All right, we'll come back to that. Is Ms. Cabrera coming or she is coming? Okay.
And he was transferred.
Yeah, but then Deputy Gordon said they took him right back.
Oh, okay.
There's 3 calendars.
We're not catching a lot of breaks. How about Garyana Stone? Ms. Stone is here. Ms. Rios?
Yes, Your Honor, I think the state wanted to approach about this case.
Yes, Your Honor.
Okay. We'll do that. We're almost done calling the calendar.
It might be just me.
Derek Epps.
Mr. X is here. I've been speaking with Ms. Williams. I believe she's on the way.
She's in trial before Joint Baxter.
Right.
I'm texting with Ms. McGillicuddy and I think Tim is on his way over.
I was told Pennington would, but he's stuck in another courtroom, maybe taking a plea. So I think we'll sit tight. You filed a immunity motion kind of late in the game, so that's swirling around out there as well.
I think we can resolve it.
Short of the immunity motion? Okay, but you need a lawyer to talk to. It sounds like it's going to be Mr. Pennington who's handling that. He's taking a plea in another courtroom and then he'll be here.
Thank you.
All right. About Choice Phillips. He's in Henry County. When did we figure that out?
He's was involved in a Henry County probation application.
But I mean, did we know long enough ago to do a production order? No. Okay.
And his attorney is on his way, He's coming from Gwinnett, so I need to let him know.
Okay. So we'll need to take care of his bond here. Huh. Okay, and then we're back to Kyrie Rhodes. All right, Ms. Wood, can we go through your cases?
Of course.
Mr. Felker is online.
Yes, I need to do a breakout session with him to see if this will resolve today.
Okay. Rasheen Walker.
I have not had contact with Rasheen Walker. so-
Okay. Could be another bench warrant, like Jared Milam. Mr. Casillas, we're waiting on the lawyers. Kendrick Wilson.
Judge, I think this one is probably gonna be one that we'll just leave on trial calendar and reserve the final plea rights. Ms. Ross has been working on placement. She had an interview set up for Mr. Wilson 2 weeks ago, and the provider, something happened and they were not able to keep the appointment. It's been rescheduled, but unfortunately it's for tomorrow.
Okay.
So I think that's probably what we should do with that case.
So just roll it to the March trial calendar, preserve final plea rights. Okay. We'll bring him out just to let him know what's going on after you've had a chance to speak with him.
Thank you.
Just talked about Diggs. Mr. Smith, position 12. My old friend. He has been excused. I think this is pretrial diversion. Okay, is it through your office or it is something that the lawyers have negotiated?
It's between defense and.
Okay, so you'll get a proposed order?
Yes, Your Honor.
Okay. Great. I think that's the calendar for this morning.
I did hear from Ms. Nick. She said she'll be here in around 10 minutes.
Great. I mean, we still have things to do, but for what we can do right now, that's where we are. So we'll try to track down Mr. Jerome, and Ms. Nix will be here. Mr. Pennington will be here, and that should allow us to move some of these cases. All right. I'm going to stay out here for a minute just to look a few things up, and then I'll get out of here. Oh, we're hopefully going to be able to do some stuff from this afternoon. And I'll turn to that in a minute. Let me just deal with a couple emails.
Sorry, we're just not raising. Or let him go to the.
Trial calendar and preserve final plea rights. And hopefully get the state to dismiss the older case.
We're just approaching about having this.
Yeah.
And one. Let's go and get Xavier. Are y'all gonna do a indictment or? Well, we shall choose a lot of people. Usually we don't need to.
Oh, and we need to talk about Ms. Stone. Why don't we do that so she doesn't have to stick around if she's not sorting things
Would you
out?
like me to
Saw
do
that.
the breakout session with?
Oh, yeah, let's do that.
Okay.
Okay. Hey, Mr. Felker, can you hear me? Yes, great. You don't need to unmute yet. You're going to need to unmute in a little bit. I'm going to move you into a breakout room so that you and Ms. Wood, your lawyer, can have a private conversation. Okay? And when she's done talking with you, I'll bring you back in here and maybe we'll work on your case out today. But she wants to have a confidential conversation with you. So she's going to go into a jury room here and log on and the two of you will talk.
Okay, thank you.
You were on, but you're not on. You're going to get back on? Okay.
Okay. Okay. Eugene and then Xavier?
Well, I would both of Eugene and Xavier to be together.
That makes sense. Okay, let's go. You ready for us?
In a minute, I gotta wait to get Ms. Wood into the breakout room.
Lingering rain. Just.
Well, Pivot, he just sent me.
Sir, you just have the room?
No.
Are you here for the Serge Jerome cases?
I'm looking to see if I have any English streams. I'm back. Yeah. Why should I? I'm gonna see what.
Oh, because of the second case. All right, they're in their little breakout room, so let's talk about Miss Stone. You're going to the back?
Are we going?
Oh, yeah, we'll just go right out there. So I saw you just followed her. You followed her. It's not back. I don't need to see. So it's use my proposals. Just do balance is I think not correct.
Thank you. Where did we go? Oh, they're in the back, okay, cool.
I'm going down to.
That's okay.
What is this? Oh, he said, right, he's here. This is good.
Right, yeah, he's, but yeah, and then, cause he got, I really didn't have school that year. Why is he here?
Call back, see. You there? I believe.
Oh, she's the best. I'll check the motion. Usually there. Right, something.
Get the doors here for you.
It's the weather.
Yeah.
Now you see the book on the water?
Gentlemen, excuse me, so.
Yes, Ms. Stone, I spoke with your lawyer and the prosecutor. They got me up to speed with your situation. You're excused for now. Your case will be on that March trial calendar. So you'll need to be here on March 12th. Ms. Rios will tell you all about that. We've preserved your final plea rights so that if you are entering a plea, you'll have an ability to withdraw it if you're unhappy with the sentence you get. I'm not saying that it will be a plea, could be some other outcome, but you will need to be here for that March trial calendar if we haven't done something with your case before then, okay? All right, thanks for being here. Ms. Wood.
Mr. Felker is ready for a negotiated plea.
Great, we'll do that in 1 second. Ms. Nix is here, and so I want to hear from her about, we've got position 5, Casillas. And it looks like Mr. Casillas's lawyer is here, he's in custody. Is that not your case?
It is.
Okay.
And we're pre-trying that.
Okay, you're talking.
Yes.
Great, then keep talking. 7 and 8 are yours, Jerry Diggs. He had some medical situation when he got brought over this morning and had to go back to the jail. So he's not here right now, he's back at the jail. I think his lawyer may be in trial. Did we confirm Christopher Campbell?
Yes, I did get a.
Christopher Campbell can't be here. So my thought is that we roll over just position 8 and maybe you'll null pros position 7 because 8 was a superseding indictment of 7. And 8 will go to the March trial calendar. We'll preserve Mr. Diggs's final plea rights because we weren't able to have that discussion today through no fault of yours, but Campbell is in trial and Diggs had whatever happened this morning. Does that work for you? It's a maybe face.
This is one where I actually made an offer a very long time ago, and so I was kind of hoping to have an answer from him as to whether he wanted to enter a plea or not.
Yep.
So I would prefer that it get reset for a final plea instead of moving to the trial.
Okay. If we can slide it onto a final plea calendar between now and then, I will do that. But I would like to keep the focus on resolving it. And so if that final plea is after the trial calendar, I probably won't do that. But no reason why. I'm happy to shoot an email to Mr. Campbell and you saying, hey, had you had a chance to talk with your client? I'm not remembering this attorney. Is this the attorney who's been on the case the whole time? No, Ms. Wood said she had it for.
Wood, and we had been talking about it, and then Mr. Campbell and I have very briefly discussed the case.
Okay.
He did send me an email a week or two ago, kind of saying, is this all discovery? And I said, yeah, that's it. And he was kind of trying to mischaracterize some of it, and so.
It's a aggravated stalking. It shouldn't be a ton of discovery.
Well, there is actually a lot because there were a large number of instances of contact.
Oh,
But
okay.
since Mr. Campbell is here, I probably shouldn't.
No, that's okay, but it's good to know. So, do you feel like he knows what the state's offer is?
Yes.
Okay. And is the alleged victim in this case a family member, a former special friend? What is the supposed connection between Mr. Diggs and the target of the stalking?
It is the former intimate partner, and she is on this image.
Okay. Then we will, I'll send an email to counsel and Ms. Nelson asking about whether Mr. Campbell has had a chance to talk with his client about working this out and letting him know. Ideally, and you may say, look, there's an expiration on the offer in advance of the trial calendar date. We can always get him in here before then. I just don't know that he can fall onto another final plea calendar between now and then.
It was final plea, which is today, is when it expires.
Okay,
But I didn't put like today's date, I put final plea.
right, which we're not able to do today. Okay, got it. All right, and we can null pros position 7, the original indictment.
Yes.
Great. I think those were your cases today, so you and Ms. Ismailova should keep talking. We'll see what we do there. Do we need an interpreter for your client? No, excellent. All right, he's here, so you guys keep talking and we'll circle back on that. So Ms. Wood, we are ready for Mr. Felker's plea.
I left a message for.
Serge Jerome.
Yeah, you're here. Whatever's easier, I got you.
All right, let's turn to position 2 and we'll get on the record. Good morning, Mr. Felker. Can you hear me?
Yes, Ron.
Great. I'm Judge McBurney and your case is on for final plea today. That case number is 25 SC 000-262. Mr. Felker, you're appearing from Baldwin State Prison. Your lawyer, Ms. Wood, is here in court, and the prosecutor, Ms. Smith, is also here. Mr. Felker, before we can start with your plea, I need to know that you're comfortable proceeding remotely like this. Are you willing to waive your right to be here in Fulton County and proceed from there?
Yes, Your Honor.
Okay. You also have a right to have Ms. Wood right next to you rather than virtually next to you. I know you two had a private conversation earlier this morning. Are you waiving your right to have Ms. Wood by your side for this plea?
Yes, Your Honor.
Okay. If at any point you need to speak with her in confidence, let me know. We'll get you on one of those breakout sessions. If you have questions, let me know. If you can't hear what's going on, wave your hands. But if anything happens that's not making sense to you or is inaudible, just share the word and we'll either explain it a different way or pump up the volume, okay?
Okay. Yes, Your
All
Honor.
right. Ms. Smith, when you're ready.
Thank you. Mr. Felkner, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Paul Whitfield Felker?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
26 years old. I did a semester at Georgia State. So high school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Felkner, do you remember being arrested on these charges?
Some of it, yeah, a little bit.
It was from a while ago. The incident was in May of 2023, and it involves an allegation, Mr. Felker, that you damaged the door of a house, apartment, something of a Naomi Torres. Does that ring a bell?
Yes, Your Honor.
Okay, that's what we're here to talk about.
All right. The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
We are not.
Mr. Felkner, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 month with the balance probated?
Yes.
Can you repeat that, please?
Yes. Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 1 month with the balance probated?
Yes, I
Got it.
understand.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes, I understand.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to the revocation for the balance of the sentence?
Yes, I understand.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Mr. Felkner, are you currently on probation?
I'm currently serving time. I have 15 years probation after I get out.
Are you serving time because you were revoked on probation, or this is part of a custodial sentence?
Custodial sentence.
Okay, and when you're done with the prison part, there's probation that follows?
Yes, Your Honor.
Got it.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, I understand.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, I understand.
Do you understand that you waive any and all defenses, including any mental health defenses, by pleading guilty today?
Yes, I understand.
Do you also understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands these rights that they'll be waiving by pleading guilty?
I am.
Mr. Faulkner, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment 25 SC 000262, how do you plead to count 1, criminal damage to property, 2nd degree, and count 2, loitering or prowling?
Guilty?
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you also understand that this must be done within 30 days from today?
Yes, I understand.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, I understand.
Thank you, Mr. Faulkner. Your Honor, if this case were to proceed to trial, the state would show that on May 29th, 2023, Atlanta Police Officer D. Holloway was dispatched to 275 Pryor Street, Southwest Atlanta, in reports of a person attempting to force his way into an apartment building. Upon arrival, the officer contacted or got into contact with the defendant, Paul Faulkner, who looked pretty sweaty and seemingly out of breath once the officer started talking to him. He was also standing outside of the apartment door with a large rock by his feet. He stated that he was just trying to check on his girlfriend who was supposed to be inside of the apartment. The officer then observed a damage to the door and detained the defendant for criminal damage. And thereafter, the officer spoke with the apartment owner, Naomi Torres, who stated that the defendant had previously dated her former roommate, that her former roommate no longer lived there anymore, and that the damage to the door was around $700. The defendant was at that time then charged with prowling and criminal damage to property in the 2nd degree. And all of this happened in Fulton County, Your Honor. And those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed to a sentence for count 1, 5 years to serve 1 month with the balance probated, and for count 2, 12 months probation to run concurrent with count 1. As far as special conditions of probation, the state is recommending for the defendant to stay away from the incident location, to stay away from the victim, Naomi Torres, to complete an anger management course, also to have a mental health evaluation with treatment if necessary, an alcohol and drug evaluation with treatment if necessary, and for the restitution for the damaged door to be reserved in this case so we can get some documentation of the actual price for that damaged door. And that is all from the state, Your Honor.
Okay. You or a colleague of yours filed a recidivist notice in this case. Mr. Felker's case was in non-complex and got transferred here because he's a repeat offender. Are you withdrawing the recidivist notice for purposes of the plea?
Yes, Your Honor.
All right. Do we have anyone on from pretrial services? In person? Woo! It's like, I thought you were in the box. 6 cycles.
Judge, I'm not able to hear if it matters.
Okay,
I'm not able-
thank you. I need you to come up to the podium. Court reporter needs to be able to take this down. Or you can use that microphone. That's all good. Not a podium guy.
That's 6 cycles. Can you hear me?
No, we're good. 6 cycles.
Okay. Conviction for ag assault, criminal damage to property in the 2nd degree. It's 23 SC 190236. Conviction out of Cobb County, ag assault, criminal damage to property 1st degree. Possession of a knife or a firearm during the commission. And I got a 2023 possession of meth, tampering with evidence conviction. That's all.
All right. Thank you, sir. Ms. Wood.
Thank you, Judge. Mr. Felker is 26 years old. He's a lifelong Georgia resident. He is a high school graduate. As you heard, he's had some college at Georgia
Ms.
State
Wood,
University.
I'm sorry to interrupt. Can you put the microphone just closer to you?
Can you hear me now?
I can, much better, thank you. And I'm sorry, can I get you just to start that over?
Yeah, she's going to start over in 1 second. How are you? Is everything good downstairs?
Yeah.
You just you needed more stuff. Do you need help carrying it down?
No.
You good?
Everything's set up. I just needed this stuff.
Your magic cords?
Yeah.
Do you want the speaker brought down there?
I don't know. I don't know what the sound is like that.
Why don't you email if you need it and we'll get it brought down?
Okay, thank
Okay,
you.
you bet. Thanks for helping out.
All right.
You got the door? Okay.
Madam Court Reporter, can you hear me from right here?
No, not really. Is your mic off?
It's on, but I can come to the podium.
Yeah, if you don't mind hitting the podium. Not sure what's going on with that.
Sorry.
Can you hear me now?
Yes, thank you.
Okay, he's 26 years old. He's a lifelong Georgia resident. He is a high school graduate. He has some college education from Georgia State University. Prior to this arrest, he was gainfully employed at Texas Roadhouse. Your Honor, we are just asking that you accept the state's recommendation. It looks like he's actually been in continuous custody between here, Cobb County, and the Department of Corrections since this incident date. So he very well may not have any probation to deal with once he finishes his sentence, but we are asking that you accept this recommendation.
I'm confused about, you're saying since May of 23, Mr. Felker's been in nonstop custody?
From my read, so he was arrested here, he did a month, then it looks like he went to Cobb County. He was brought back here in September of 2023 and did a week here. And then there was a CPO return to Cobb County. He was brought back here again, December 2023, yet another CPO return. And then he went into Department of Corrections custody, January 2024.
Okay. And Mr. Felker, you went into DOC custody where you are now because of one of the pleas you took, either here or in Cobb?
Yeah, the plea in Cobb and the info.
Okay. What was your sentence in Cobb?
5 years, 15 years probation. 5 years.
So 20 to serve 5 with 15 on probation?
5 to serve, 15 on probation, yeah.
Got it. Okay. So 5 years to serve followed by 15 on probation.
Yes, sir.
What's your current release date?
March 2028, I can parole out in April 2027.
Okay. All right. But regardless of when you parole out or get out, you then have 15 years of probation through the Cobb case?
Yes, Your Honor.
Okay. All right. Do you have any questions about what we've been discussing here about your case?
Yeah, so it's 5 years, it's for probation, the sentence is for probation? 5 years.
So the recommendation is 1 month in custody. You've already done that 1 month. You've done a bunch of months, followed by really it would be 4 years and 11 months of probation. Given your Cobb sentence, I may structure this a little differently, but we'll talk about it because you have the right to say, I don't want that sentence. Forget it, Judge. So hold off on questions about the sentence till I tell you what I think I'm going to do about the sentence. And we'll go from there. Do you have other questions about what we've been talking about?
No, Your Honor.
Okay. When did you get arrested the day this happened?
Yes, Your Honor.
Okay, and you've been in jail nonstop since then?
Yes, Your Honor.
All right. And the Ms. Torres, who's the named victim in this case, it sounds like that wasn't your ex-girlfriend, that was her roommate?
Yeah, it was on accident. I was having some mental health issues and I was on drugs. So
Okay. And you thought your girlfriend would be at that address?
yeah, I thought she was in trouble and I was trying to help her.
Okay. Got it. Are you getting medication now to help with the mental health situation?
Yes, Your Honor.
Okay. What are you taking?
Zyprexa and Zoloft.
Okay. How often do you get that?
I get it nightly.
Pardon me?
I get it every night.
Okay. Did you get it last night?
Yes, Your Honor.
And when you take it, does it make you woozy or confused or anything?
No, sir. No, Your Honor.
Okay. All right. You feel like you've understood what we've been discussing?
Yes, Your Honor.
All right. Well, Mr. Felker, I find there's a factual basis for your plea. Way back in May of 23, almost 3 years ago, you were having an episode, and it sounds like you were self-medicating at the time. You were concerned that your girlfriend might be in danger and you needed to get through that door. That understandably was pretty scary for Ms. Torres, who was on the other side of the door, and the police got there. Unfortunately, no one got hurt. I also find that your plea is knowing and voluntary. That means you've understood what we've been talking about and no one's forcing you to enter this plea. Do you agree with that?
Yes, Your Honor.
Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Your Honor.
And Mr. Felker, can we electronically put your signature on the indictment indicating your guilty plea?
Yes, Your Honor.
All right. Where's home for you when you do get out, whether that's next year or in a couple years? Is it Cobb or Fulton?
No, I'm gonna live with my sister in Tucker, Georgia.
In Tucker? And she said that's okay?
Yeah.
Okay. All right. Well, Mr. Felker, what I'm going to do is sentence you to 2 years to serve on count 1 and 12 months to serve on count 2. I'm going to run those concurrently with each other, and you are going to get credit from May 29th of 2023 for those 2 years.
So the 2 years that I have to serve, I've already served them?
That's the math.
Okay.
All right.
Yes, Your Honor.
You still have to serve whatever the calculation is going to be for the Cobb County case. So you may get your early release, your parole date. You may not. This won't have any impact on it. This is a separate incident. But since you're going to have 15 years of probation through Cobb, I don't see a reason to have this sort of running alongside next to it. So this will close that case out. All right.
Yes, Your Honor.
Ms. Wood, anything else?
No, Judge, thank you.
Ms. Smith?
So I don't have to serve any more time, just the probation?
So I'm not giving you any probation. I'm sentencing you to 2 years in custody. But by law, you get credit for the time you've been in since you were arrested on this case. And my understanding, I don't know that it was May 29th. The jail log says it was June of 23. Really doesn't matter because if you add 2 years to June of 23, you get to June of 25. And here we are in February of 26. So you know better than we do. You've been in for at least 2 years. That was your sentence for this case. So when you get out, you will be on probation, but just for that Cobb case, not for this.
Okay, thank you, Your Honor.
All right, good luck with things. And thank you to the folks at Baldwin State for making Mr. Felker available. Yes, ma'am.
Are we not imposing a restitution?
So if you end up coming back with some figures, I'm happy to modify the sentence to do that. Okay? Because you asked to leave it open in that respect, and I'm happy. We can always revisit and do an amended sentence. All right. Thanks, Mr. Felker. You're good to go.
Thank you, Judge.
You bet.
Judge, I was not able to hear the ADA when she asked you a question because she turned away from the mic. If it's not, doesn't need to be on the record, that's fine. But if it does, I better.
We're good. It doesn't. We're all set. Thank you.
Judge.
All right, thank you, Baldwin State. Mr. Felker's all done.
Yes, sir.
All right, see if there are any updates. We got lots of people in court. Ms. Cabrera is here. Your lucky day. Unfortunately, we finally get you here and Mr. Roberts is not here.
Yeah.
But we do need to chart a course forward for him. He is,
On Thursday.
oh,
We have court Thursday, I think it's trial count calls.
We do.
More Williams on that calendar.
yeah,
So, state gave me an offer that I actually think that Mr. Roberts will take. But like I told the state, when she gives him, I have enough time to get to him, so.
and it will resolve his 2 open extortion cases and it'll handle the revocation.
What I understand.
That's my understanding, is that, okay,
And so I honestly think that he'll accept it.
great.
So I asked, Ms. Nelson if she would bring him over, so she'll bring him over on Thursday, so hopefully we'll resolve that.
Okay, that's fantastic. We'll probably do that early on in that calendar, even though there's the big trial calendar call, just because Mr. Roberts is a presence, and when he's around, it can get complicated.
And then, you have a, meeting today at 4:00. I may miss your 4:00 meeting, the calendar for Thursday. But I only have.
I do, look at that, okay,
I only have Memorial Williams on the calendar.
okay.
It's a murder case that has, multiple defendants.
That's the 3-ish, right? We have Hairston specially set to go. It's a murder, a little older. So yours would be a backup if we could fit it. It's only a 1-week trial calendar.
Right, so that's our only call. I did speak to Mr. Body last week, I ran into him at DeKalb. And so we talked about it, there's a special prosecutor there.
Okay,
But because he has COVID, if it was just me and Adam, then it might be a week.
got
It's
it.
not just me and Adam.
Right.
So I'm pretty sure it's longer.
Okay, got it.
So that would be my only announcement for the afternoon. I have,
You're ready to go on it, if we reach it.
unfortunately,
Yeah, okay. It's not going away. Okay,
Yeah, I doubt it. Adam and I, of course, will have another conversation
Yep.
about it. But it's not, I don't get the impression today.
Yep. Okay. So maybe good fortune with Mr. Roberts on Thursday. He'll at least be here. We'll see what happens. And we'll call the calendar for your other case and
Yeah, and
see what goes there.
if I get done with the pop, I'll still join, but if not, at least you know what my position was on this.
Oh, about this afternoon. Got it. Okay, great. I think that was it for you today.
Right, now I have 2 more calls on Thursday.
All right.
Thank you, Judge.
Thanks for stopping by. I don't think we ever heard anything from Mr. Jerome. Nope.
Yes, Your Honor, I'm here.
Oh, look at that. I hear his voice.
Yes.
Fantastic. What's going on, Mr. Jerome?
Hi, good morning.
Good morning. Good to see you.
Yes, Your Honor, I was on leave. I was given the Zoom link to log in.
Okay, I'm sorry we're disturbing your leave.
No, it's fine.
We've got Mr. Rhodes. You've got 2 cases with Mr. Rhodes. He's on for final plea. And we've got Ms. Smith, the prosecutor, here. Do you and Ms. Smith need to talk a little bit or tell me where you are in terms of Mr. Rhodes's cases? It's like I said, today is final plea. If Mr. Rhodes does not resolve his cases today, they roll over to our March trial calendar. That's March 12th. And we can always try them. They are similar. No, they're not similar. And in fact, they're 2 different lawyers handling the cases. It's more complicated than I thought, Mr. Jerome. One of the cases has a special prosecutor on it, and one has the very special line prosecutor, Ms. Smith, on it. So you got 2 lawyers you got to do business with. Do you want to have a conversation with them, or what works for you?
So, Your Honor, I've actually spoken to both of them already.
Okay.
So we have offers on both cases, and I've spoke to Mr. Rhodes about it. And I would like to, if possible, have a global plea. And so we haven't been able to. I'll tell you this. I've gotten offers on both of these last week. I spoke to Mr. Rhodes about it last week.
Yeah.
And I would like to get a global plea on both these cases, but the offers are not exactly in line right now. So I would ask if we could have some additional time to do that. because we have spoken a little bit. They're not far apart, but I'd like to see if possibly I could get them, basically down so that we could do a global plea on both these cases.
Okay. Ms. Holler, you've had a chance to connect with Mr. Jerome?
I sent him an email with the offer this past weekend. My offer is the high one.
Okay.
I know you're shocked.
Yeah.
I do not see that we're gonna come down from that.
Okay.
So I'm happy to talk.
People can keep talking. And Ms. Smith, you've communicated an offer from your case to Mr. Jerome as well.
Yes, and that was going to be the global offer for my case or concurrent.
Okay, so it's global in the sense that yours would run concurrent, but if the offer on the other case is higher than what Mr. Rhodes was hoping for, that's just sort of where he's stuck.
Right.
Okay. Mr. Jerome, I can sort of meet you halfway, and that would be that I keep Mr. Rhodes's final plea rights intact, and we just have this, it's going to be on the March trial calendar. That's not moving. One of the cases is from 24, so it's already getting old. The other is from medium late last year. And so we got to figure out what resolution is going to look like. So they'll appear on the March trial calendar. That's a month away. So that gives you time amongst all the other things I know you're dealing with to get with your client and maybe to beg and plead and haggle with the prosecutors to see if you can get them to a different space. But if not, Mr. Rhodes would still be able to enter a plea on the day we call the calendar, March 12th. And if he's unhappy with how that plea plays out, he could withdraw the plea and just go to trial on that calendar.
Okay, all right, that sounds good.
He's here. I'm going to ask the deputy to bring him out just so he gets a quick contact with you, me, and the prosecutor so he knows what's going on. You all right with that?
Yes, that's fine.
Great. Can you bring him out, please?
If I can ask, I'm actually teaching a class on March 12th. Is there any way to do it before March 12th? He is working remotely.
If you all negotiate it, yes, of course. So that would just mean that if we hit the 12th, it hasn't worked out. But if you all reach a point, even if it's going to be non-negotiated and it's just not that far apart, we could do that on any day. We just need notice so that we can produce Mr. Rhodes. And obviously it would need to work for Mr. Jerome's schedule and yours. But you've got a whole bunch of days in which to make that happen. Hey, come on out, Mr. Rhodes. If you'll just come to the podium. Hey, Mr. Rhodes.
How you doing, Mark?
I'm all right. We've got your lawyer, Mr. Jerome, on the screen, and the two prosecutors who have your two cases are here in court, Ms. Smith, Ms. Hollander. And Mr. Rhodes, today was going to be the last day that you could enter a plea when you'd have the right to withdraw that plea if you were unhappy with the sentence you got. So just as a made-up number, if Mr. Jerome was asking for 2 and I gave you 4, you could say, Judge, I was willing to take 2, but with 4, I'd rather go to trial. I say, okay, great, we'll go to trial instead. We're not able to do that today. Mr. Jerome had leave, and I need to honor that. He is graciously plugging in virtually, as you can see. But he is going to be spending more time with you and, importantly, with the prosecutors. It sounds like where he wants to try to get their offer is not where they are right now. They're recommending more time than you and your lawyer are comfortable with. I will see you at the latest on March 12th. That's the trial calendar your cases are on. And on March 12th, we'll call on the calendar to figure out who's going to trial, who's working their case out. It may be before March 12th that you and Mr. Jerome decide we're going to come on in and we're going to enter a plea, but it may be non-negotiated because Mr. Jerome's going to ask for a number that's different from what the prosecutors are asking for. That's a decision for you and your lawyer to make. He will be out to see you to talk about that. I just wanted you to know why you were brought over today. We were going to have that conversation. We can't because Mr. Jerome's not here to advocate more directly on your behalf. But we'll see if you guys can work something out before the 12th, or I'll see you on the 12th and we'll either do a plea or go to trial. Make sense? Any questions?
No, not really.
Okay. Mr. Jerome, what can we tell Mr. Rhodes about when he might expect to see you next?
You'll see me next week, Tari.
There you go. he will make it by next week to talk more about where these two cases can go. All right?
All right.
All right, see ya.
All right, thank you, Judge.
Thank you, sir. You're free to go.
Thank you.
Can I be excused from?
Yes, ma'am. Mr. Pennington is wrapping up the last plea where he is, and then he'll be here. No one had forgotten about you. Did Rasheen Walker's here. All right, great. Don't go anywhere till we talk about your case, okay? All right, how about Jared Milam? Nope, that is a bench warrant. Mr. Casillas, hey. Okay,
I spoke with the state and, was trying to offer that, I do believe will resolve the case, but, I just, I'm requesting that I have some time to relay that to my client, discuss it with my client. Ms. Nix has graciously agreed to, extend the offer until the 27th of February.
okay.
And, I believe, I'll definitely let the court and Ms. Nix know before then what my client decides.
Okay, we'll bring him out in a minute just so that I can explain that. My notes will be, we're moving this to the trial calendar. That's the default. But if you all sort something out before then just work with Ms. Nelson to get the case put on we don't need to do a notice calendar because you'll be asking for it. You just need to be able to have Mr. Casillas produced from the jail and we'll be able to take it from there.
Yeah,
So you have your internal deadline of the 27th and you'll stay focused on that. I'm just going to note that this is going to the trial calendar.
Yes, sir.
Okay, does that work for you, Ms. Nix? Can we bring Mr. Casillas out, please? Good morning, Mr. Casillas. How are you?
Good.
Good. I was speaking with your lawyer about your case. She is working very hard on your behalf to see if there can be a plea in the case. She's got a few more weeks to negotiate with the state before the state withdraws its offer. I will see you at the latest in about 1 month. Your case is on a March 12th trial calendar. Your lawyer suggests that it may get worked out before then, in which case I'll see you then, and we would do this by way of a plea. If that doesn't work out, then I'll see you on March 12th, and we'll make a plan for trial, okay? Any questions for me?
No, Your Honor.
All right. Anything else, counsel?
No, Your Honor.
Ms. Nix?
Yes, sir.
All right. So, Ms. Nix, I think that's it for you. I will get an email out to you and Mr. Campbell about Mr. Diggs saying yes to the offer, to see if that shakes anything up. And we'll no-pros the older version of the indictment. All right?
Thank you.
You bet.
Your Honor, that concludes my business.
You may.
Guys.
Morning.
I make an announcement, Victor Gordon for Joyce Phillips.
Appreciate you being here.
Apologies for my tardiness.
No. You called, you let us know. We learned this morning that Mr. Phillips is in Henry County.
Yes, Judge. I thought the court was aware, but apparently not.
No.
So, I would ask that the state, I know today's the final plea, if we can keep it open until the next hearing, which is the 12th.
Yeah, so what we'll do, we'll hear from Ms. Smith, see if she's willing to do that. I hope she will be, because it's really not anyone's fault that Mr. Phillips can't be here today for us to have the conversation. March 12th is the trial calendar that Mr. Phillips's case is on. Just looking at the charges here, doesn't seem like a trial case, but could be. We'll keep his final plea rights open. Between now and then, if you and Ms. Smith reach an agreement, we should bring everyone in and we can get Mr. Phillips produced from Henry County or get him on virtually if they do that in Henry County, just to save you the that March 12th is going to be a crazy day because everyone's here and lots of moving parts. And even if it is a plea that day, that's going to be a long day for you. I don't know when we'll get to it. So if you all sort something out before, let Ms. Nelson know and we can tuck you in. You could say, hey, this Wednesday works, whatever. And we'll either get Mr. Phillips produced or, like I said, patch him in and handle it that way.
I'll do that. I'll touch base with Ms. Smith first and then contact the board, Ms. Nelson.
Yep. Does that work for you, Ms. Smith?
Yes.
No issue keeping the offer open? Okay. All right. Mr. Phillips got picked up for, is it new charges or why is he in Henry County?
By probation violation.
Okay, but what's
The other case, we resolved another case a few months back.
got it, and that triggered the warrant out of Henry County.
That triggered, yeah, but he had some payment fines.
Okay, additional issues. Okay, are you representing Mr. Phillips in all these different pieces or just this?
All of the different reasons.
You're the corporate lawyer. Okay, all right. Appreciate you being here.
Thank you. We have an excuse.
Yes, sir.
Have a great day.
Do we know where Ms. Wood went? Is she back there? Yeah, she's back there. Okay. Hey,
So I am here on behalf of 88 Williams.
yes, and Mr. Jurgen would very much like to talk to you about Mr. Epps.
Okay. What side? Sure. So were you spoken to counsel, they have a witness, which is the victim in the case, that's gonna provide some information to the state. We're just having someone else come up here, one of the advocates, to be a part of the meeting.
Okay.
She should be here 5 minutes or so.
Great. You're welcome to use the jury room if it's helpful to meet in there
Yeah.
rather than standing out in the hallway. If that makes a safer environment for that conversation.
Yep.
Okay,
That
great.
makes sense, and I would anticipate, I don't know what's gonna be said, so maybe we'll just hold off on announcements.
Good. We'll keep an open mind, see where we go.
Okay.
All right,
I'll just wait, I'll come back here as soon as, someone's. Okay.
will you have Deputy Gordon get me once whatever's going on back there is done? Because I think we have another plea. And maybe she's talking with Mr. Wilson. I think Mr. Walker is supposed to be a plea.
Yes, possible.
Okay, so Walker and Wilson.
I'll let them know.
Okay, thank you. Oh, I gotta sign this first. Oh, and here he comes. Hey. Ms. Wood.
Yes.
We have Mr. Walker and Mr. Wilson from this morning, and then we can talk about afternoon stuff too, if people are here. What's happening with the two Ws?
I need to talk to Mr. Walker once more. We're seeing if we can work that one out today.
Great.
It's probably gonna be quicker if we can just go ahead and do Mr. Wilson.
Okay,
And I've already spoken to him, so.
great. All right. It's position 6 on the calendar. Yeah. Did you get the history on a guy named Kendrick Douglas? It's like, yeah, he has 4 murder convictions. It's not this guy.
Oh, just even on the trial calendar, nothing's happening for real.
On Mr. Wilson?
Yes, just.
Oh, it's not a plea.
No.
Oh, well, can you let him know he doesn't need to panic? Oh, well, he's gone.
Sorry. This is the one where the program, we're still working on.
Got it. Okay. Okay. Hey, Mr. Wilson.
How you doing, sir?
I'm all right. Your case is on the calendar today to see if we were working it out in a setting where you could withdraw your plea if the sentence you got was something you didn't like. But Ms. Wood told me first thing this morning that they are working hard, her office, to get you a program that they can recommend as part of a sentence. And ideally, you were to have met with those intake people from the program earlier, but through no fault of yours, that meeting got canceled and it was rescheduled for tomorrow.
Wow.
So we don't know if you're in the program, which means they can't advocate for it. And Ms. Wood has asked that I just move your case to the trial calendar, which doesn't mean you're going to have a trial. You can have one if you want. But that's the next natural stop is the trial calendar. That's on March 12th. So the latest you would be back here is March 12th. Now, if before then you get into the program and the two sides agree, hey, let's do a plea, whether it's negotiated or non-negotiated, we'll get you here and knock out that plea.
Yes, sir.
So the longest wait will be about a month to the trial calendar. The shortest would be if the interview goes well tomorrow, then maybe the following week or something, we get you in here for either a negotiated plea or a non-negotiated plea.
Okay, I got you.
Any questions?
No, sir.
What's the program?
Salvation, huh?
All right. That's something you're interested in?
Yes, sir.
Okay.
I need it.
You need it. What? Tell me why you need it.
I need housing.
Okay. Is there any substance abuse issue in the mix?
Yes, sir.
No drug court?
He was rejected because of an old armed robbery conviction, Judge.
Really?
I know, it's a
I'm
bummer.
sorry, Mr. Wilson. That's too bad. Salvation Army, it may be.
Don't
Okay.
forget to call Mr.
I got you.
Okay,
All right,
all
thank you.
right, I'll see you.
Ms.
soon.
Smith, anything? Okay. All right, why don't you talk with Mr.
Yes.
Walker, and I will be back out in a minute.
Yes, for sure. Okay. Okay. I'm gonna do it.
Excuse me, Your Honor.
Back to the jail? That's what I've been asking for all along. Thank you.
But it's his fault.
Kitchen duty?
It's his fault. Explain you what he did.
What happened?
Disappointed.
Oh, over the weekend? Because he bet on the Patriots? That's just dumb, but that's not. When will we see Sergeant Palmer again? He's still recovering? Yikes. All right.
Excuse me, Your Honor.
Yes, ma'am.
Will Laura Charles be heard on the docket today for 9 a.m.?
Yes, that's a bond hearing that we were going to do this afternoon, but we're going to do it this morning because a couple things came up this afternoon. So Ms. Wood, I think, is the lawyer. It's either Ms. Wood or Ms. Rios, but we will have that bond hearing. Ms. Wood, are you working with Ms. Charles or is that Ms. Rios? Okay.
I think everybody, she's gone, so I think everyone else for me.
Okay, great. A family member of Ms. Charles just spoke up to ask if we were doing that. I explained we were, but we were going to handle Mr. Walker's situation first.
And this is a non-negotiated privilege.
Okay, I'll be out in just a second.
Okay.
Thank you, Your Honor, for confirmation.
You bet. Thanks for your patience. Be right back.
Yes. Laura Charles, it was Michelle Williams, Timothy, is he covering me? Or who knows?
I don't see him in the afternoon.
It's an add-on, yeah, it's an add-on.
Is this next case going to be a plea?
I'm sorry?
Is this next case going to be a plea? Are we about to do another plea?
It's a plea, yes, ma'am.
Okay, thank you.
Will you write down your address and your phone number for me? Thank you.
Oh, yeah. Okay.
Thank you.
That's a fancy,
It's an iPhone.
it's a huge iPhone. Is that personal or that's from work?
It's mine. Perfect.
Yes.
Yep.
Okay, let's get on the record, please. This is position 3 from our calendar this morning. State versus Rasheen Walker. Mr. Walker is at the podium with his lawyer, Ms. Wood. Ms. Smith is representing the state. It's indictment 25 SC 001 554. And Mr. Walker, Ms. Wood tells me you are prepared to enter a non-negotiated plea right now. Is that correct?
Yes, Your Honor.
Okay, the way that's going to work is that in a moment, Ms. Smith is going to swear you in and then ask you a bunch of questions about you and your case and your rights. You need to answer those questions truthfully and completely. If you have any questions that come up, you need to let Ms. Wood or me know because I need to do my best to answer them, or your lawyer does. In the end, I will impose a sentence. It sounds like this is non-negotiated, so Ms. Wood is going to be asking for something different than what the prosecutor is asking for. If the sentence that I impose is more severe than what Ms. Wood asks for, by example, if Ms. Wood asks for 2 years probation and I give you 4 years probation, that's a longer sentence. You'll have the opportunity to talk to Ms. Wood about it, and if you want to say no, thank you, you can back out of the deal, and it's not a plea anymore, and we'll just see you in March for a trial. You understand that?
Yes, sir.
But if I impose a sentence that is identical to what your lawyer asked for, then you're bound by your plea. Understand?
Yes, Your Honor.
Okay, Ms. Smith?
Mr. Walker, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Rasheen Walker.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there any medication that you would normally take that you haven't been given this morning?
No.
How old are you and how far have you gone in school?
44. I graduated high school.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
We do.
Mr. Walker, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants related to these charges?
No.
We are not.
Do you understand that this is a non-negotiated or blind plea and that the state will recommend a sentence to the court?
Yes.
And were you made aware of the state's previous offer of 10 years to serve 1 with the balance probated?
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence that's recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal law, governmental unit, or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that if you are charged with a crime in the future, that this plea may be used to enhance that sentencing, even on a federal case?
Yes.
Are you currently on probation?
Yes.
Are you aware that if you're currently on probation, your probation may be revoked based on you entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf and remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Walker, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 001554, how do you plead to count 1, possession of cocaine with intent to distribute, and count 2, possession and use of drug-related objects?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
And do you understand that that has to happen within 30 days from today?
Yes.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
Thank you, Mr. Walker. Your Honor, if this case were to proceed to trial, the state would show that on
July.
Yes, Your Honor. On July 5th, 2023, at approximately 3:15 p.m., Officer Hoffman with the Atlanta Police Department were on routine patrol around the area of 300 Peachtree Street Northwest, an area that was known to have high drug activity, both selling and using. While driving through the area, the officers observed a male clenching something in his right fist at the sight of the marked patrol cars and abruptly shoved that fist into his pants and turned away and began to walk away from the officers. Given the individual's odd behavior and movements upon seeing the police, the drug activity known to happen in the area, and the fact that the officers had made numerous arrests in that same vicinity, this made the officers approach the person in this case who was later identified as the defendant, Mr. Walker. Upon approaching the defendant, the officers asked Mr. Walker to stop, and eventually he did. And when they approached him, they asked, what did he have on him? He immediately dropped his pants and showed that he didn't have anything. However, the officers did see something that was like balled up in his underwear. The officers then asked what was it, and it appeared to be crack cocaine. They were able to grab or obtain whatever that substance was, and it was later identified and confirmed by the GBI as 3 grams of cocaine. The officers then found search that was after he was detained. The officers did find a small digital scale along with $132.66 that was in his pocket. At that point, the defendant was taken into custody for the charges we have here today. All of this occurred in Fulton County. Regarding the plea or the recommendation from the state is recommending for count 1, 10 years to serve 1 year with the balance probated, and for count 2, 12 months probation to run concurrent with count 1. Regarding the special conditions of probation, the state is recommending a 4th Amendment waiver, a drug and alcohol evaluation with treatment if necessary, for the money seized during this arrest to be forfeited, for the defendant to be gainfully employed, and for the defendant to complete 60 hours of community service. And that's all from the state, Your Honor.
All right, thank you. And in terms of criminal history, I see there's a recidivist notice. It lists 12 convictions, so you don't need to, you may have more than 12, but I got 12. You may have less than 12, in which case the recidivist notice is interesting.
Yeah, I got a story.
At least 12, okay. Tell me the most recent, that's what I'm intrigued by. The most recent one I've got was from August of 23, an aggravated stalking out of
Ag
Fulton.
assault, 22 SC 182-223.
Yeah,
2020 ag battery conviction.
Sir,
okay,
can you start over and speak more into the microphone for me?
sure.
Thank you.
2022. I got a ag assault, ag stalking, 22 SC 182-223.
Okay. And is that what he's on probation for now?
Correct.
Okay, thank you. But that conviction was a few months after. Thank you. That conviction was a few months after this case, so this isn't gonna mess with his probation.
Got it.
How much probation does Mr. Walker have for that case?
1 year, 6 months.
1 year, 6 months, okay. All right, Ms. Wood?
Thank you, Judge. Mr. Walker is 44 years old. He is a lifelong Atlanta resident. He is a high school graduate. He has 3 children that he provides for by working at Oz Pizza. He's been there for the past year. Your Honor, we are asking the court to consider a sentence of 5 years probation on count 1, 12 months probation on count 2. We have no issue with the drug and alcohol evaluation and treatment, no issue with forfeiting the money. He is gainfully employed, so that condition won't be an issue as well. And then I would just ask for 25 hours community service. Your Honor, given the age of the case and the fact that he hasn't had any other run-ins with the law, we think that's an appropriate sentence. So we would ask that you consider that for this outcome.
Okay. Mr. Walker, what do you do at Oz Pizza?
I'm a pizza cook, sir.
Like throwing the thing up in the air?
Yes,
And you've been there about a year?
yes.
Okay, how'd you get the job?
I applied online
Okay.
and they called me a couple of days later.
How many days a week do you work?
5,
What days?
Tuesday through Saturday.
Okay. And that's pretty regular employment? I mean, each week you're going in and doing all that?
Every day, sir.
Ms. Wood mentioned you have 3 kids. How old are your kids?
10, 11, and 6.
All of them in school?
Yes,
Do they stay with you?
yes.
Who else is in your household?
Just me and my mom for right now and my kids.
Where is the kid's mother?
Well, we had, since the incident, what I had, what I'm on probation for, she had moved with her mom in St. Louis.
Oh, the victim in the case you're on probation for is their mother.
Mm-hmm.
Okay. And she moved to St. Louis?
Yeah,
But the kids stayed here?
with me. Yes, sir.
Okay. And they and you and your mother all live in the same place?
Yes, sir.
Does your mother work?
Well, she get disability
Okay. All right.
and she really helped me watch the kids while I be at work, so.
Got it. Okay. Anything else you want to add?
Well, no, you can call my job and tell, you can see that, that I never miss a day and I'm always on time. You know, you can call my probation officer too.
Ms., I'm going to do something along those lines. Ms. Simpson, what does your system show in terms of how Mr. Walker has done on probation in the 22 SC case?
Judge, I'm not able to hear that if I need to.
Okay, no, I'll add it. The probation officer's in the jury box.
He was just approved in December for unsupervised probation.
Okay, approved in December for unsupervised supervision, so non-supervision probation. Okay.
Which means he's been compliant.
He's been compliant. Great. Okay, thank you. Those are all good things, Mr. Walker. So, Mr. Walker, I find there's a factual basis for your plea, excuse me, and that your plea is knowing and voluntary. Knowing meaning you've understood what we've been talking about. Any questions about anything?
No, Your Honor.
No? Voluntary means no one's forcing you to enter this plea. You've decided that it's in your best interest. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Your Honor.
And Mr. Walker, can we electronically affix your name to the indictment?
Yes.
All right, we'll do that. Ms. Smith, there is a recidivist notice filed in this case. Are you withdrawing it for purposes of this plea?
Yes, Your Honor.
Mr. Walker, this incident was a while ago. Since then, it sounds like you, for the most part, stayed out of trouble. You pled guilty to that situation involving your kid's mom, but then once you've been on probation, it sounds like that's gone well. You've got a good job, but this is also your 13th conviction. So I can't ignore all that, but I also appreciate that a whole lot of your criminal history is way, way, way back in time. You were 18, 19, and maybe not being as thoughtful and responsible as you are now that you have 3 kids. And it sounds like you helped take care of your mom as well. I'm hopeful that most of those days are behind you, but at least as of July of 23, you still had a little hustle on the side. That is the kind of hustle that if it doesn't go well, you'll be taken away from your kids and they need you around. If mom is in, meaning their mom is in St. Louis, and your mom is getting up there in age, you need to be an active presence in their life, which means Oz Pizza needs to be how you make your money and not something else. The way I'm going to strike the balance, given your criminal history, the fact that you were doing this, but that was 2.5 years ago, is that I'm going to sentence you on count 1 to 5 years, count 2 to 12 months. Those will both be probated. A special condition of your probation, Mr. Walker, is that you will have 6 weekends in custody, although your weekends will be Sunday, Monday. So you'll turn yourself in to the county jail on when do you get off work?
4 o'clock.
4 o'clock? So you could go turn yourself in to the county jail after work on Saturday, and then you'd get out on Monday at the same time. So if you turn yourself in at 6, you get out Monday at 6. So it's not going to interfere with your job. Those weekends will start not this weekend. I'll give you a minute to get your life coordinated so you can talk to your mom about it and work. It shouldn't impact work. But we would start with that weekend of that Saturday is the 21st of February. So you turn yourself in Saturday night and you'd be there through Monday evening. So it's the 22nd, 23rd. You do 6 of those in a row. Don't miss any. And you will have taken care of the custodial piece of your sentence. I'll also have there be a 4th Amendment waiver, which means your probation officer can search your stuff if he or she needs to. It sounds like you and probation get along pretty well. I don't think that's going to be an issue. You will forfeit the money that was seized from you back in July of 23. I'm going to have you do 40 hours of community service, a little less than what the state asked for because you're busy. You're dad of 3 and you're working. You don't need to worry about those community service hours until you're done with your weekends in jail. But I do want you to knock out those 40 within the first 6 months of your probation. So that's not hanging over your head, and it'll make it that you can get to unsupervised probation sooner. And then you will submit to a drug and alcohol abuse evaluation. That's just you meeting with a doctor or someone who knows a lot about what substance abuse looks like. And if that person recommends any treatment, you'll need to follow that treatment. But if that person says, Mr. Walker's doesn't have any issues in that space, then you don't need to worry about it. And I will set a behavioral incentive date of February 11th of 2029. That's 3 years from now. If you've done everything you need to do, you're on unsupervised probation, et cetera, they can petition to close your case out early because by then you're going to be 47 years old. If you figured out how to stay out of trouble, you will have shown everyone that you figured out how to stay out of trouble. And we can end this early. If not, if there've been hiccups, you get arrested for something, you just do all 5 years of probation. But you have the ability to end it early if things are going well. Do you feel like you understand the sentence that I imposed?
Yes, I do, sir.
It is less than what the state asked for, but in particular, that 6 weekends in jail provision is more severe than what your lawyer asked for. I'm going to have you talk with Ms. Wood for a moment to see if you want to go forward with this or if you want to say, no, thanks, I'd rather go to trial, and then we'll see what happens after trial. Okay? So talk with Ms. Wood, please.
Here.
Well, that was a quick conversation. All right, so Mr. Walker, you want to go forward with the plea?
Yes, I do, Your Honor.
Okay. Ms. Simpson, does Mr. Walker need to report, or because he's already on probation, how do things change?
He would need to contact his supervising officer,
Thanks, Chris.
Other information, okay.
Do you know the name of your supervising officer?
Yeah.
he's a contractor about Monday, just.
Okay, so Mr. Walker, you'll need to contact your supervising probation officer, Ms. Gresham, whoever it is, by Monday, to let her know you've got this new case. By then, it'll be in the system. She won't be surprised by it. She'll say, oh, here it is, 25 SC, blah, blah, blah. She'll see the conditions, and then you'll just work with her on that. You'll be supervised again. I know you were just reaching the point where you could be unsupervised. We're resetting that process because this is a different case. But if you're working with the same probation officer, all the goodwill that you earned by doing the things you needed to do, I think will flow back pretty quickly, and we'll just see how it goes. The main thing will be to knock out those weekends in custody, okay?
Yes.
Any questions about anything?
No, Your Honor.
Ms. Wood, anything else?
No, Judge, thank you.
Ms. Smith? All right.
For your reminder.
Judge, can I look about the weekend, custody, well, I have to with your election.
Okay, all right,
Okay,
All right.
all right, call me with any questions, okay?
all
All
right.
right, you're free to go. All right, have a nice day.
Yeah, nothing. You gotta go?
I didn't know. President Allen.
Oh, you didn't have all the, okay. Do you have a copy of it?
I got his down face.
Okay. Okay. Okay.
I didn't know we were gonna start on that now.
It's just the people in jail we may try to knock out now, but I don't know that we're resolving anything. So I'd sit tight to see what we do. Okay, that's it. Okay, great. So, what is the update, Mr. Jurgen, Mr. Bennington, on the EPS matter?
So, Your Honor, state does have an offer on file in the case. What happened today was that the victim in the case came in, he wanted to say they tried to reach out to the victim before and then not been able to speak to him. We had some contact with his mother, but we spoke with him directly. I think, Your Honor, after speaking with him, we're gonna take what he's told us into consideration. The facts of the case haven't changed. But it is helpful to understand, the victim's view of his relationship with his father going forward. We understand, we've learned that, you know, his brother passed away since this, and that
As a result of this situation, totally unrelated.
and I don't know the details of that, but it's not related to this at all.
Okay,
But that, you know, he feels like that, his father's changed some since then, and that he is hopeful for the relationship going forward. He's also said he's not in fear of his father. The state is still gonna have concerns. This was a shots fired case.
Mhm.
So the current offer, that we have, I would say in my review of it, seems like a fair offer. But I do understand that defense may have some, you know, there may be further discussions about special conditions. This looks like a case that should resolve short of trial. I would request a reset of final plea, but if you wish to put this to a trial calendar and then us just report back the status, we'll leave that in the court's discretion. I don't know what defense counsel believes would be the proper way to handle this going forward, but that's the state's announcement.
okay. What says the defense?
Whichever is easiest for you, Your Honor. We were speaking with Ms. Williams, I believe, late Friday night. She said she was not able to get in contact with the son. We provided all the information. They've spoken. She indicated that she would make a offer with fewer conditions, less probation, once they came into contact. I know she wasn't able to be here today.
Okay,
Just waiting for that information to get to her. She could update the offer or not.
okay.
Just keep the final plea rates
Why don't we do that? I very much appreciate Mr. Pennington parachuting in, new to the case, not new to the practice, but new to the case, and not wanting to upset whatever balance Ms. Williams had put into place. I'm gonna keep it on the trial calendar. That's still a month away. That's plenty of time. Mr. Jurgen, for you to have more discussions with Ms. Williams. She's just in trial right now. It's not like she's disappeared on us, she's right down the hall. But she's not available now. So this will be on the March 12th trial calendar. If between now and then nothing's happened, you and Mr. Epps will need to be here and we'll figure out what we're doing. That's going to be, as you may have heard me tell some of the other lawyers, a pretty busy, crazy day. So if you and Ms. Williams are able to reach a point where you think it's worth it, either because it's negotiated or it's close enough that a non-negotiated plea might be in your client's interest, let Ms. Nelson know and we'll make time for that well before March 12th. And we could knock it out then. I'll preserve Mr. Epps's final plea rights. And worst case scenario, just in terms of duration, I'll see everyone on March 12th. Okay? Anything else from the state?
No, Your Honor.
Okay, thanks for being here.
Thank you, Your Honor. Do we need to sign those or? maybe
Nope,
those?
you're good.
Yeah, oh, are you leaving?
Yeah,
Are you covering the bond motions for the afternoon calendar?
that would be, that would go Potter,
Oh,
or
okay.
AJ Potter. Sign it.
Is that who we need for Ms. Charles?
Yeah.
Okay.
Yeah, I'll text her. Or take the break for that. Whatever. And what? Oh, I know, no, we just set the date like 30 minutes ago instead of. Oh. Okay. So then who do you have downstairs?
Oh yeah, let's talk about what we can do. So we did not move a lot off this final plea calendar. Do we have, so position 1 from the plea and arraignment waiver scheduling order, position 2, is that you?
Yes, he is mine, Judge. It's,
He has a new case too.
yeah, I think there actually might be 3. Anyways, it's not gonna resolve today.
Okay,
So that will be a waiver. It'll be very quick.
okay, so we could bring him up and do that. Okay, position 3, that person's not late yet.
I don't have a good number for that person, so hopefully get that notice.
Okay. Or, doesn't say jail, just says juvenile.
He's downstairs.
Oh, he is downstairs. Okay. Will that be you or does that mean that it's Ms. Gordon or something?
Let me double check.
Okay.
Cause it's always confusing, because now Mr. Rhodes is taking.
Some of them. It's his name's listed on there.
He's not in their office anymore, so I
Oh,
always double check.
right. Okay. Number 5 is yours.
Yeah. That one, so I just texted Ms. Potter, who will be covering for Ms. Williams.
Oh, so she would be the advocate on the other side about what to do with the bench warrant. Okay. 6 is a revocation.
It's ready to go.
All right. And then 7 is a revocation.
And that one is ready to go. There's a number of family members who are in route.
Okay, so we'll wait for them. All right. So we could do Spence, we could do Blue.
Okay.
And then we'll wait on Ms. Potter. Has someone reached out to Ms. Potter?
Yes. That's
Okay. She did? Okay.
Good, it looks like for Kanye Williams. Number 4, does anyone know?
Yeah.
So Mr. Rhodes put that entry in on January 5th, so it looks like he will be the one taking care of that.
Okay. I think we're good.
That's it. Thank you.
You got to go downstairs to get them? Oh, they're here.
Judge McBurney, the gentleman from pretrial services, could I get his name?
He's coming to introduce himself.
Okay, thank you.
You want me to spell it?
Yeah, that'd be great. Thank you.
First name is Tousssaint. Last name Howard.
I'm sorry, did you say A-I-N-T?
Tousssaint.
E-N-T.
AINT.
N-T. Okay, thank you.
Yes. Last name Howard.
Okay, perfect. Thank you so much.
Who do we have here?
This is Mr. Terry Spence, Judge, number 6.
Hey, Mr. Spence.
Good afternoon, Mr.
To come up here and talk real clear, okay?
Good afternoon, Sir Honor.
Good morning. It's still morning. I know it feels like you've been here for a while, but it's still morning. Mr. Spence, you're position 6 on our afternoon calendar, probably why you're saying afternoon, but we're trying to knock some of these things out this morning. Your case is 22 SC 181-101. And you, sir, are on probation in December of 2023, so a while ago. 2 years ago, I signed a warrant that said that you had gotten in trouble again, that you got arrested for removing cargo or baggage from a bus terminal, theft by taking. This would have been in October of 23. Didn't report to probation and you had not registered. You're supposed to register as part of your situation. So those were the allegations. That was a few years ago. I'm going to ask Ms. Wood to tell me if she's got any update on those allegations and then whether you're admitting to any of those violations or challenging them or what we're going to do today. And I'm going to hear from the state. I may hear a little bit from probation. We'll figure out a plan, okay?
Yes, sir.
All right, Ms. Wood?
Thank you, Judge. We are admitting to the arrest and the conviction now because thanks to Ms. Simpson, I know that he resolved this case on January 12th of this year. He has been in custody since he was brought from Clayton County, so he's been here 29 days. We're just asking that you revoke 30 days, reinstate, and I've explained to him that he really needs to make sure he goes to change that address as soon as he's released from custody.
Go to that address.
Upstairs.
Got it, to register.
Yes.
Okay, let me find.
Okay. Is your Clayton County stuff? Yeah. Okay.
Oh, so this was in Clayton County, so it must have been something at maybe the airport.
Yes, sir.
Got it. How long did you stay in custody in Clayton County?
28 and a half months.
That's a long time. And it was about supposedly stealing luggage? That's a yes?
Yes, sir.
Okay. Huh. You've got 4 years and a little less than 5 months remaining on this case. Do you have a place to stay when you get out?
Yeah, I'm gonna be either staying with one of my friends, either in the Midtown. I'm gonna be between Midtown, Buckhead, and Sandy Springs, because my daughter stays in Sandy Springs, so I'm gonna be back and forth.
How old's your daughter?
My daughter's 31.
Okay, so she's all grown and she'll let you stay with her?
Yeah.
Okay, and then who's in Midtown, a friend?
Yeah.
And who's in Buckhead?
My baby's mother.
Okay. And that baby would be your daughter who's 31 or a different child?
That'll be my 5-year-old daughter. Smart.
You have a 5-year-old as well. Got it. And the mother of your 5-year-old is the one who lives in Buckhead?
Correct.
Okay. And does your 5-year-old stay with her?
Yes, sir.
What's your 5-year-old's name?
Jada.
Jada. Okay. So just processing all this, as a result of the charges, Mr. Spence has done really 29 months. It was 28 months in Clayton. He's got about a month here. So he's done over 2 years. Understood. Ms. Smith, what are your thoughts about what to do with Mr. Spence's situation?
Yes, Your Honor, in this case, the state will be following the recommendation of probation, which is to revoke those 30 days and probably reinstate the balance.
Okay. Do you have a fixed address? I know you said bouncing and that's okay, except probation kind of needs to know where to find you. And more importantly, when you go register, since you have to register, you need to give the sheriff not 3 addresses.
I'm more likely probably give him my friend's address that lives on over there by King Memorial, because that King Memorial, that's Fulton County.
Okay.
I got,
Is that the Midtown address you were talking about, or is that a 4th address?
that's
Number 4.
number 4.
Okay. Well,
Well,
Mr. Spence, I just want to protect you from more trouble. You are free to move around during the days, but probation needs to be able to find you and not have to guess, wait, is he in Buckhead or is he with his daughter up in Sandy Springs? Where is this man?
More likely I'm gonna be in Fullerton.
In Fulton.
In Fulton.
Okay, but it sounds like all those addresses are in Fulton. Buckhead's in Fulton and Sandy Springs is in Fulton, but you're saying this King Memorial is the,
Fitzgerald, I think it's like 83 Fitzgerald
okay,
at King Memorial train station, because I have to go over to the Mercy Chair to get back on my map.
oh, you're saying staying there makes the most sense for transport.
Right.
Okay, and who stays there now?
My gay friend named Slick.
Okay. Got it. His name is Slick or Slate?
Slick.
Slick. All right, and is that an apartment?
It's a house.
It's a house. What makes you think that Slick is going to say, hey, you're here, come on in, you can stay?
Because my ex is his best friend.
Okay, is your ex the mother of Jada or it's a different ex?
It's a different ex.
Okay, you have a complicated life, Mr. Spence. I'm not prying. I just want to minimize the risk that 6 months from now, we're together again and you're dressed like that, and that's not going to be great for you. All right. Well, do you have any questions about what's going on?
No, sir.
Ms. Simpson, anything you want to add?
Make sure that he registers.
He will need to register pronto. All right, here's what I'm going to do, Mr. Spence. I will, because you have admitted to basically the allegations that you committed these offenses, you pled to them already down in Clayton. I'm going to revoke 30 days of your probation and reinstate the balance. That may seem like a small number, but it actually reflects the fact that you did 28 months for this crime in Clayton already, and that would be more than a sufficient revocation. So I'll revoke 30 days, reinstate the balance. You've got 48 hours, 2 days to go to the 9th floor and register again.
I'll be down there tomorrow.
Great, sounds like a good plan. And you need to keep probation.
Yeah, I'm gonna report to the office first, then I'm going to my probation.
Good, they're near each other. Knock them both out, and let them know where it is you're staying, okay?
Okay.
All right, Ms. Smith, anything else? Ms. Wood?
No, just thank you.
All right,
What do you mean? Yeah, he did. Right.
Oh, what, okay, yeah, sure. And then don't forget. So upstairs and then probation. My handwriting. All right, there you go.
Okay.
Good luck to you, Mr. Spence. How are you? Yeah, sure. Right. So, yes. Okay. No. So all the person. We can keep it, okay, then to the side. Okay, so I think, Judge, can we see who's on the Zoom?
there is a Horace, Kamani Charles, someone Charles Joseph, Nikki with a heart, a Samsung phone.
We're
And-
most of Lord Charles' family members trying to figure out what's going on now.
They're all Miss Charles's family.
Her
Got it.
kids, her sisters.
Thank you. That's helpful. It's a lot of Charles support.
I can give you that number. Because he's going to do about, if you can be my right? And so that should be done, and then number Laura Charles. And you think this is an issue? Yeah. No, I've talked to this person several times. Okay, so yes, and like I said, he should be on the call. And then for Laura Charles, we do Roger. Yes, are you at now? Yeah. Oh, okay, cool. Oh, like an evidentiary? Yeah. Oh, okay. We were gonna do like a non-negotiable stipulation. Oh, okay, okay, yeah, okay. Oh. Cause the probation recommendation was a year. Yeah. Yes, so then we were just gonna go non-negotiable. Okay, gotcha. And then this one? So that's. Correct. Okay, oh yes, okay, so I was talking to Michelle about this one, so. That's right, so because it's either, it's so complicated, but I also don't for sure know where that is. But yeah, so I have, we just heard all their families on the call. So yeah, it's just volunteering today. Okay. Are you okay with this? Rob, yeah, I think, let me check my notes, because I talked to them about it now. That should be fine. Yes, yes, I love it. I know, I just do. Yeah, let me double check just real quick with the family. But yeah. What I spoke with Amy at 15. Okay, yeah, that was. I might be here at 4 o'clock. You want to take a seat?
Yeah.
Okay, so then. so anyway. I told you, I was like, looking at this. I like this. Yes, it's nice. Correct. And then. No, but I don't, isn't it? No, it's Nelson Road, but hold on.
Why is it effective to?
Yeah. You wanna do that right now? Or wait, okay, cause he's coming back, okay. So.
Honestly, it depends on the circumstance.
Yeah.
Especially.
When did you go to President Children?
Last January, right after that trial that we have continued.
You know that case is still pending?
I know, yeah, I know, like he's getting
Anyway.
Yeah, that would have been, it was like January.
That was literally like a year ago.
Yeah, like January last year.
Oh my God, so what court are you in?
I'll be in Lethbridge.
Okay.
I'm living from Farmer in Lethbridge and.
Nice.
That's an excellent, you know.
Yay.
Morning, Judge.
Hey, how are you? Thank you for filling in.
I've been in here.
I know who you are. I'm glad you're here. I appreciate it. So we've got Miss Charles's bond
Yes.
we need to work through, and then we can't do leak yet because there are people coming for leak. Is that right?
Yes, Judge.
And was Miss Potter going to cover anything else, or was those were the two?
Wycliffe, Charles, and Zeke.
Oh, right, Wycliffe, and that's sorting out. Okay, can we do Wycliffe and Charles, or do you guys need more time?
I think I just gave a phone number, a phone call needs to be made for Wycliffe.
Okay,
That's why I was asking Forrest, who was on the Zoom call. I'm not sure, he might need to fall off to take a phone call.
that's someone connected to Wycliffe? Okay,
I can do that now.
Okay, yeah.
Yeah.
Call him really quickly.
do we have a last name?
I do, Judge, but I can't remember what it is.
Okay. Mr. Horace? Can you hear me? And it's Miss Potter who's going to be calling him? Okay. Mr. Horace. I don't want to kick him out because then he can't get back in.
And Judge McBurney, is this going to be on the record?
No, I'll let you know when we're on the record. We're just trying to get someone available for the prosecutor to talk to.
Yes, thank you.
Oh, he unmuted. Hey, Mr. Horace, can you hear me?
She could be aggressive. Yeah, she's here.
All right, Ms. Fisher, you ready?
Yes, Judge, sorry, I was muted. Yes, I'm ready.
No, you don't have to apologize. We had been sort of at ease for a little bit, but we're going to get on the record, so I want to make sure you were ready to go. This is the case from this afternoon's bond hearing. It's State versus Laura Charles. No.
Ms. Wycliffe. I
Oh,
apologize, Judge. I'm so sorry.
strike that.
Hi.
Thought we were waiting to do that. Hi, Ms. Wycliffe.
Hi.
You're also on this afternoon's calendar. You're on a plea and arraignment calendar. And we'll get on the record on this one as well. Your case is 25 SC 005-211. How do you pronounce your first name?
Marjorie.
All right, I'm going to call you Ms. Wycliffe. You're here with Ms. Wood, and we have Ms. Potter from the District Attorney's Office to give the state's perspective. You missed court at one point, and that led to a bench warrant. You've been picked up on that bench warrant, and we're going to talk about whether I should set aside that bench warrant or leave it in place. I'm going to let Ms. Wood start with the conversation, and we'll go from there, okay?
Yeah.
But let me get your case up on the screen here since I had Ms. Charles's case on. That's all right.
We can do Miss Charles next.
Whenever we're ready, we should do that. She has a bunch of people on the Zoom. Here's Ms. Wycliffe. Okay, so you were supposed to be here. Not quite sure what you missed.
I'm also, I don't.
I guess it was plea and arraignment in October. It was in October of last year, October 7th, we had plea and arraignment. So it would have been my first time meeting you meeting Ms. Wood, and there was no Ms. Wycliffe. So I signed a warrant, and you have been picked up on that warrant, which is what we're going to talk about now. If I should set that aside, and if so, what the plan should be to make sure that you do show up for future court dates, okay? All right, Ms. Wood.
Thank you, Judge. So Miss Wycliffe is 33 years old. She's originally from New Orleans. However, she moved to Atlanta in 2021 to be closer to family. But update, she now lives in Fort Worth, Texas.
Yeah, I've got an address in Adams Fall Lane.
Yes.
That's you?
Yes.
Okay.
So she moved there prior to that October date. I spoke with her and her family. I think the breakdown was they updated the address with the bonding company and of course just didn't get it updated with the clerk's office, and that's been the breakdown. She was picked up in Fort Worth, so she's been in custody a little longer than it's showing, which she's been here 23 days. Your Honor, she's got 3 children. Her oldest is 15, and then she has a 4-year-old and a 1-year-old. I asked Horace to be on the call in case the court had any questions for him. I believe all 3 children are with him currently. He is desperately needing mom back out to help.
Horace is a gentleman in Fort Worth?
Yes.
Yes.
Okay, and who is he to you?
That is my kid's father.
All 3 kids?
No, just the last 2, my 4-year-old and my 1-year-old.
Okay. The 15-year-old?
Yes, they're all there with him.
Right. The 15-year-old is your biological child or his?
Mine.
Mine, yours. Okay, got it. But all 5 of you were living together. What's Horace's last name?
Foreman.
Mr. Foreman. You and Mr. Foreman were living in Fort Worth with 3 kids.
With 3 kids.
And then you got picked up for some reason and they found that you had a warrant all the way back here.
Yes, he had to, yes.
So, Your Honor, yes, so all 3 kids are with her. The defects case that was open as a result of this is closed out, so the child is back with her and Horace. Judge, she was gainfully employed working for a Walmart fulfillment center at the time of this arrest. And Judge, just to let the court know, Ms. Williams and I have already started the process of negotiating this. I had shared some mitigating evidence with her. I'm very, very confident this is a case that we can resolve via Zoom. It's my understanding, I believe this is the first arrest. Definitely no major history here from my research, Judge. So that's why Ms. Williams and I had actually been talking about hopefully resolving this case. We didn't quite get there today. That's why I'm just asking for the bench warrant to be lifted and the bond reinstated.
So I may not pronounce it correctly. Amaya?
Yes.
That's your child?
Yes.
Okay, and that's the alleged victim in this case. Her last name is Charles?
Yes.
Okay, so Amaya Charles, is that the 15 or the 4 or the 1?
15.
Okay, the oldest child.
Yes.
Got it, and she's still with you?
Yes, she never was taken away from me.
Okay, so she's still with you?
Yes.
Okay, all right. And she's in school somewhere in Fort Worth?
Yes.
All right. So your request, Ms. Wood, is that I set aside the bench warrant and then Ms. Wycliffe can get back to Fort Worth and get back to Walmart. Does Mr. Foreman work?
He isn't right now because he has to set aside with the kids and do the duties with the kids. So he had to stop working due to that.
Oh, so how are people paying for food and rent?
Well, I mean, we save up and stuff like that so he could take a break right now so he can take care of the kids until hopefully I can get back home to them so he can start back out working.
Get back to work. When he is working, what is he doing?
He was driving trucks
You seem not sure what he was doing.
because he was that's what his career is, driving the dump trucks and stuff like that. So I don't know the name of the company and stuff like that yet.
He's driving not like long haul going to California. It's big dump trucks at construction sites with dirt and rocks and all that. Okay. Okay. And this address in Fort Worth, is that a house or an apartment?
A house.
Do you all own it or lease it or?
We lease it.
Okay. Your family, brothers, sisters, parents, are New Orleans?
Yes.
Got it. So what's the Fort Worth connection?
I have a best friend that stays out there. She's been staying out there over 10 years. So we just kind of moved there, like to help one another, because she was out here, I was out here, she was out there. So I just moved closer.
Okay. All right. Ms. Potter, what are the state's thoughts about how we handle this?
Sure, yes, Judge. The notes I have for ADA Williams.
Potter, I'm gonna need you to, Ms. Potter, I'm sorry to interrupt. I'm gonna need you.
Oh, yep. Sorry, we're better with the microphone now.
Thank you. Can you hear me now?
Yes, thank you.
That since the children are safe with the father, all three of them, and in school, we will consent to set aside the bench warrant. The one concern I do have, though, is that if this is something that they plan to resolve via probation, she will need to, I think, be present for an interview to get that transferred to Texas. So she would have to maybe at least come back to Georgia once.
Okay, that's a fair point. I'm not saying it's being resolved with probation. That's negotiations between your lawyer and the prosecutor, and I don't know what I'll do when I hear all that. But if the way your case resolves, Ms. Wycliffe, is a plea and you are on felony probation, you would need to be in Georgia for a little while to get plugged in with probation, et cetera. So that's just something to keep in mind as you and Ms. Wood are discussing with the prosecutor where this is going to fall. And Ms. Wood knows that, so she'll keep you posted.
You know, misdemeanor probation, you don't have to be in Georgia.
Understood, but Ms. Potter makes a good point that
Absolutely.
there's some aspects to a plea that could mean that even we could even take the plea while Ms. Wycliffe is in Fort Worth, but she would then need to post haste get here to plug in with probation.
Absolutely, Judge.
Okay, all right. But you recognize you may need to come back. There's no guarantee that the case is going to work out exactly as you and Ms. Wood might want it to work out. Yes?
Yes.
Okay. I appreciate your desire to stay there and not be back here, but that it may be that you need to come back to court. And it'd be great if you did it on your own volition rather than on how did they get you here? A bus? A plane?
No, I guess the van that they pick you up in.
You were in Fort Worth. I don't know. You
Yeah,
drove all the way from Texas to here in a van?
It took us a few days.
Okay. And they like keep you in a hotel or they stop at different jails?
Yeah.
So you roll in late at night and there's tumbleweeds and there's.
We went
jail.
up north, then came back down here.
Oh, so it was not even an express. It was like a group. You had to drop some people off in
Went
Tulsa.
like 12 jails. Yes.
Well, my hope is if you come back here, it is in your own car or a plane ticket that you buy or a Greyhound ticket. But it's important that you understand you may need to be back here to resolve your case.
Yes.
Okay. Then I'll set aside the bench warrant. Let me look at your bond order. It has no further violent contact with Amaya and no corporal punishment on any of your children. How's it? So those conditions still apply. Those are good conditions anyway, whether you're on bond or not as a parent. But you'll need to make sure you comply with that.
Yes.
Ms. Potter, you had stood up at one point. Was there something more?
We want the bond conditions to stay in place, because we do realize that she can have contact with the victim.
Right.
But just no violent contact.
Yep. In fact, they're going to be cohabiting. So it's no violent contact with Amaya. And then Ms. Wood will be working with Ms. Williams, who's a colleague of Ms. Potter's, and we'll see where this case goes. Let me see. Well, we never even did a scheduling order. In fact, we didn't do a waiver of arraignment.
I got it, Judge, I'll do it today.
Great. So Ms. Wood will do the waiver of arraignment. We'll get a scheduling order and we'll see where it goes. What about your job? Will it still be there?
Hopefully, yes.
Has anyone reached out to Walmart to say, hey, can Ms. Wycliffe still work there?
Yeah, but I mean, they don't answer like that, so 9
Find
times
out.
out, yeah.
Okay. Ms. Potter, did you have a chance to speak to Mr. Foreman? I know you were trying to reach him.
Yes, that's Horace.
That is?
Yes.
Okay.
He should be online as well.
He is. I just want to make sure whatever that communication was addressed questions or concerns you might have had.
Yep, yes, Judge, thank you.
All right, then we're good. Anything else, Ms. Wood?
No, Judge, thank you.
All right, Ms. Wycliffe, how are you getting home?
I'll figure that out once I get released.
All right.
Thank you. Oops, sorry.
This has been tough. Just stay right here and make sure you speak clearly into the mic so the court will hear you.
Okay.
All right. Now we're going to get on the record in State versus Charles. Ms. Laura Charles is out here in court. Good morning, ma'am.
Good morning.
She is here with her lawyer, Ms. Wood. We have Ms. Potter here for the state. The case is 26 SC 000103. And Ms. Charles, we're just going to talk about bond today. You've been indicted for cruelty to children. The allegation is that you did not adequately care for a child in your care and custody by depriving her of the necessary sustenance. Ms. Wood is going to tell me why you should get a bond and what that bond should look like. Ms. Potter is going to agree or disagree, and I'll hear from her. And then I'll tell you if I am going to set a bond and what the conditions would be. You have many, many supporters who are online. You can't necessarily see them, but you should know that there's a whole cadre of folks who are here in support of you.
Thank you, thank you.
Thank them. Ms. Wood.
Thank you, Judge. So Ms. Charles has been in custody 37 days. She's in no bond status currently. From my research, I believe this should be her first felony arrest ever. We're asking the court to consider setting a $1,000 bond on this charge, the cruelty to children charge, Judge. She's 39 years old. She's originally from Miami, Florida. She's lived here in Atlanta since 2018. She's got a good, stable address. Part of our urgency in getting her before the court is because we're very concerned that she's actually going to lose that place if she sits in custody much longer.
This is Hidden Brook Court.
Yes, sir.
Is that a house or an apartment?
It's a house.
Okay, you're leasing it?
Yes.
Okay, who else is there?
Just me and my kids.
Okay, so they're not paying the rent right now. How old are your kids?
18, well, 19, 16, 15, and then I have my niece and nephew.
Okay,
Yes,
so there are 5 kids. The niece and nephew are what ages?
14 and 12.
Okay, so the 19-year-old actually could be paying the rent if that person's out there making lots of money, but everyone else should be in school.
Yes.
Okay. And you take care of all 5 of those with no help?
No, no help.
Okay. So is the 19-year-old taking care of them right now?
Actually, they're with his father right now.
The 19-year-old's father?
Yes.
And is that in the Atlanta area?
No, it's actually in Smyrna.
But it's not in Louisiana?
But
I mean, they didn't have to cross state lines or something?
yes.
Okay, but it's far from school, it's not
Yes, it
home,
is.
et cetera. Okay. Got it.
So yes, Judge, so there's her three children and then the nephew and the niece. The niece is actually the alleged victim in this case.
Is that the 12 or the 14-year-old?
14.
Okay.
So I'm not clear. I don't think she's actually with them right now.
No, she's
Okay.
not.
So like a no contact or whatever it needs to be is fine with us. Judge, she's a small business owner. She is a chef. She also does some DoorDash. She does have some college education. Again, this is another case that I've been working with Ms. Williams on. The pre-indictment attorney had been working with Ms. Charles's family. They got us some evidence, some video evidence that I've shared with Ms. Williams. So we are actively working, hopefully on a resolution soon for this case as well. I believe, so Ms. Charles actually took in her niece and nephew from state custody after the untimely passing of Ms. Charles's brother. So she was doing a good deed and it's turned into a bit of a nightmare for her. So we're just asking that you set a reasonable bond in this case so that she can get out and take care of her children, Judge.
So I don't want to get into a whole lot of the allegations. It may be Ms. Potter knows very little because it wasn't her case to begin with. So I don't want us to guess or speculate. But you close by saying, I want to get Ms. Charles out so she can take care of her kids. And the main allegation is she wasn't taking care of a kid in the household. What should reassure me that the other 4 children who will still be there are going to have enough food on the table or whatever was going on in this case?
Sure. Well, one of the videos that I share with the state just completely shows that some of the allegations in the police report are inaccurate. This is a troubled young lady, the niece, Judge. I believe, it's my understanding, Ms. Charles was actually in the process of relinquishing her back to the state because of some behavioral issues, Judge.
Just the niece, not the nephew?
Yeah.
Correct.
Okay.
That were, she needs a little bit more structure than Ms. Charles can give.
Yep.
I don't, again, we don't actually even know where the niece is currently. I believe her biological mother is in a different state. And so given that there's been, to my knowledge, I have subpoenaed defect records, but I don't think we've gotten them back yet. I don't think there's been any other allegations from her children or the nephew. I think this was an isolated incident, Judge. So
Okay.
that's why I'm comfortable asking for what I'm asking for.
Okay. Got it. Ms. Potter, tell me what you know about the situation and what you think ought to happen with bond.
Yes, Judge. We do agree that this was an isolated incident with the defendant and her niece. We have not had contact with her either. So we've that's been difficult. So we don't know her wishes going forward. But we would say in the meantime to have no contact with the niece. It looks like based on her at least misdemeanor criminal history, we found her to be a low to medium risk and would recommend a bond between 10 and 20,000.
Okay. And Ms. Wood, you said a 1,000? That's the figure you came. Okay. What's the small business that you own, Ms. Charles?
It's called Laura's Creole Flavor. It's the restaurant.
What's it called?
Laura's Creole Flavor.
Creole?
Yes.
Okay. Got it. Okay. So you are a chef. You do the cooking at this restaurant?
Yes.
Okay. And is it a pop-up or it's a restaurant?
It's a food trailer.
Okay. Got it. A food truck.
Mm-hmm.
All right. The 19-year-old, is that a boy or a girl?
It's a boy.
Does he work outside the home?
Currently, right now, no, he's in college.
Oh, he's in college?
Yes.
Is he local or off at Fort Valley or at Tulane?
No,
or-
he's local.
Local? Okay. And then the 16 and the 15-year-old are in high school,
Yeah,
and I guess the 12-year-old would be in middle
middle
school.
school,
Okay. And you don't know where the 14-year-old is?
no.
Okay. Do you have any questions about anything we've discussed?
No.
All right. Well, I conferred with pretrial before we had this hearing, and their information is that Ms. Charles has 4 cycles, no felonies, and no violent arrests. So that's consistent with what Ms. Potter had as well. Ms. Charles, I will set a bond. I'm going to set it at $5,000. It'll be through the sheriff's 10% program. So the money that gets put up, whether you directly or friends and family members, they'll get back when the case is resolved. And you'll be required to stay at the Hidden Brook Court address. And you can have no contact with the alleged victim in the case. It sounds like she's somewhere else anyway, but if for some reason this case takes a while to resolve and DFACS reaches out or family reaches out saying, hey, could she come back? The answer is unfortunately no. It may be fortunately, but she's not allowed, you're not allowed to be around her, which means you wouldn't be in a position to say, I'll take care of her again. Even if you felt like that was a way to help out family like you were before. That's a relationship that needs to be put on hold until we sort out these allegations and figure out what happened and didn't happen and the consequences of that. Okay?
Okay.
None of your work requires you to leave the state of Georgia? It's
No.
all local?
Yeah, it's all local.
Okay, all right. Then I think we are set. Ms. Potter, any other conditions you wanted to see?
No, Judge, thank you.
Okay, all right. Then that is the plan. Ms. Wood will be in touch with you. Do we need to do a,
Waiver?
yes.
I will do that.
You will do a waiver and that'll get discovery flowing in your direction.
Yes, Judge.
Okay, all right. Thank you.
Thank you, thank you.
Thank you, Ms. Potter. All right, have a good one. Same.
All right, anything else you want to knock out this morning? Blue is up, I think. I don't know, he just walked away.
I'm ready on leave, but I was hoping that they were gonna be here. I'm gonna call the room.
Okay. Is Blue up? Okay. Well, Ms. Wood is calling to see where the family is for Leak. Is Leak up? Okay, they were driving from far away. If they're close, we're gonna try to do that. Otherwise, we may just reconvene at 1:30, give everyone lunch. We'll see. Blue is not up, so my thought was we just reconvene at 1:30 unless the family said, we're in the elevators.
They're not on the elevator.
Okay.
So that's not good.
So just to preview, we've got Blue, which will be an arraignment or waiver of arraignment. And you think Blue may have a third case?
I thought I saw something, it might not be here, Judge.
Okay.
Not a full.
All right, and then Cawthon, is that yours?
Yes.
Okay, that's just, that person is gonna show up at 1:30. Willingham, you said Mr. Rhodes has that.
Yes.
So hopefully he'll be here at 1:30 and then Leak. So that's everything. Okay. Thanks, guys. Let's be back here at 1:30. Ms. Fisher, are you good to go? You take a lunch break and then we'll see you at 1:30?
Yes, Judge, I'll be back at 1:30.
Thank you.
Thank you.
I'll bring my laptop.
Thank you, Abby, I appreciate you.
Just so I don't know if I need purposes.
Yeah, it would.
You might take.
I don't think so. I think we're good. No,
So.
Still, when you come back.
no, we're good.
You're probably better services. Great.
You wanna keep that?
Okay.
No, because these folks are all done, so I'll give you your special document. Thanks.
I'll be there Thursday too.
Okay.
Is it one calendar Thursday?
Yeah, no, you're absolutely right.
Let's look. I think Thursday's the trial calendar call, so woo, you drew a biggie.
My plan is I'm gonna be at the jail for a big, like, visit day.
Yeah, take these on.
He's all
Oh, yeah.
this. So I'll.
Right now, it just says trial calendar, but there is also a probation revocation that may happen. And someone named Jerry Hewley is pleading, and I don't know that he's on the calendar. So you should reach out to Ms. Nelson and she can give you all the info. Deidre Nelson is my litigation manager. She can give you the stuff that's not on the calendar. All right? All right, good afternoon. We have a couple things. I don't know how many we'll be able to knock out before I need to take care of one other project, but I got stuck on a long meeting just now. Ms. Wood, are we good with Mr. Blue? Do you want to do that?
Yep, that'll be quick, Judge.
And what about, did Mr. Cawthon make it? You were not forecasting that he'd be here. All right, Ms. Smith, did you want a bench warrant for Mr. Cawthon?
Yes, Your Honor.
All right. And what about Willingham? Is his, hey, how are you? It is. Were we just going to do arraignment?
No, Judge, I filed a motion for bond. I think back in December, we're hoping to be for bond.
Okay. Ms. Smith, were you ready to do that? It doesn't say it on the calendar. It doesn't mean that we can't do it. You may just need to make sure Ms. Smith is, I don't know if the victim knew.
I can prepare for that motion for bond.
Okay. I'll take a look at that. Let's bring Mr. Blue out and handle that, and then we'll talk. Mr. Rhodes.
Just when I was giving you an idea of what he has going on, so it's only 2 indicted cases, there's the 3rd unindicted, and then a foreign county hold. So I still
Okay.
have to say we're doing a waiver today.
All right.
Both cases.
You'll do a waiver on both?
I filed them, but yes.
Great. Well, Mr. Blue, slide that way a little bit. I'm Judge McBurney. You have a couple cases that have been assigned to me. Ms. Wood was just telling me you actually have 4 pieces of business with the criminal justice system. You've got 2 indicted cases here in Fulton. We're going to talk real briefly about those today. You have an unindicted case here, and then you've got a hold from Clayton County. But your 2 indicted cases are the ones that Ms. Wood told me she's waiving arraignment for on your behalf, which means she's entering a plea of not guilty. Excuse me, I'll get a scheduling order entered, and then the prosecutor, Ms. Smith, who's seated behind you in red, will be getting all the discovery in those cases to Ms. Wood so that the 2 of you can talk about strengths and weaknesses in the case and figure out how you want to move forward. So it's a pretty brief encounter we're having today, but I wanted to introduce myself and let you know what the forecast is. That discovery will be provided soon. Ms. Wood will then have a chance to meet with you and decide if she's going to file any motions or not. If there are no motions, then we can move you on to a plea calendar. If there are motions, like a motion to suppress, something like that, then we'll hear those motions and move forward that way. Do you have any questions?
Not really. No, sir.
Okay. Well, Ms. Wood will be out to see you soon once she gets that discovery, and you probably have a whole bunch of questions for her. She's probably the better person for questions about your cases and whatnot. But I wanted to give you at least a framework for what to expect moving forward. Okay?
Yes, sir.
All right. See you soon.
All right,
All right, I'll be soon. Okay.
All right. Let me look here. So I see a January 16th motion for bond. Is that what you're talking about?
Yes, I misspoke.
That's okay. So you have filed a motion for bond. It didn't hit our radar. But what I'm going to propose we do is handle the arraignment today, and then we figure out how quickly we could bring you and Mr. Willingham back. We don't even need to do a published calendar if you're willing to be flexible about that. If there has to be notice and all that, then you know it's 2 weeks. I can appreciate why he and you and his family would be anxious to have a bond hearing, and you're entitled to that. But of course, the state needs an opportunity to contact the alleged victim to provide any information from that side if the state's going to do that. So that's my proposal. Does that work?
That much I understand. I will say, Judge, he is an SB 448, he's 16, and he turned 17 on the 19th, at which point he would be transferred to Rice Street. I would request if this were to be rescheduled that
It'd be before the 19th.
Yes.
Okay, a very reasonable request. And what I'm gonna ask you to do, once we're done talking, is you can chat with Ms. Nelson. And she could look at the schedule to say, hey, as long as you don't need a published calendar, we could slot you in here, here, or here. And then you'll leave knowing what that date is. So you and the family will know when to be back, and Ms. Smith will know that she needs to reach out to the alleged victim. Okay? So my thought is we still bring Mr. Willingham out to do the waiver of arraignment. I don't see one in the docket, so there's a form for you to fill out, so we can take care of that. That'll get discovery flowing in your direction. Well, that's impressive. Okay. It'll keep it flowing in your direction. Can we bring Mr. Willingham out, please?
Most likely be within. Because of. Right. We're doing today is cleaning your okay. That's all. But you will be rescheduled for court with him.
Good afternoon, Mr. Willingham.
Good afternoon.
I'm Judge McBurney. It's nice to meet you. I was just talking with your lawyer, Mr. Rhodes, and he let me know that he had filed a bond motion on your behalf. He did that about 3 weeks ago. That did not hit my radar, so we didn't put you down on the calendar today for the bond hearing. You're here for the arraignment or waiver of arraignment. Sounds like Mr. Rhodes is going to waive arraignment, which just means he's entering a plea of not guilty for you, and that'll keep the case moving along. Mr. Rhodes has understandably pressed to have this bond hearing ASAP. He shared with me that you have a birthday coming up, and it's a birthday that could lead to you being relocated if you're still in custody. So I told your lawyer that we will do what we can to get that bond hearing to happen before the 19th. To manage your expectations, I don't know that I'm going to set a bond, but you're certainly entitled to have bond heard, where Mr. Rhodes can say, here's why Mr. Willingham should get a bond, here's what it should look like, here's the family support he has, all the things that he's good at doing. And if I find that persuasive, I can set a bond. But I don't want you to think because the judge is setting a bond hearing, that means I'm going to get one. I can't know that now. I don't know much about you. I don't know much about the case. And I have to evaluate how safe it would be for you, for Rafael Cruz and others, for you to be out on bond versus where you are now. So we will have that bond hearing. Today is just the formality of your lawyer waiving arraignment and starting the process of moving your case towards resolution. Do you have any questions?
No, sir.
Okay. I will likely see you in the next week or so when we can get this scheduled for a bond hearing. Mr. Rhodes will be here, and I'm sure he'll want to have here whatever family support or friend support that he can bring.
Okay.
Ms. Smith, anything on behalf of the state?
No, Judge.
Mr. Rhodes, anything else?
Nothing else, Judge.
Okay, thank you. When you're done with the waiver form, you can hand it to Ms. Nelson and you guys can talk about scheduling. The only thing left, I believe, is the Broderick Leak revocation hearing. I see lots of people here. Are these the people who have traveled a great distance to be here for Mr. Leak?
That's correct, Judge.
All right. Did you guys get lunch yet? No? Good. You're gonna be able to get lunch now. I gotta take care of something else. And when I come back, we will handle the revocation hearing for Mr. Leak. Tried to move it to the morning, but Ms. Wood asked that we wait so you all could be here. I'll always honor that request. If it's family members of the defendant, it's good for him to have you here. It's good for you to see and hear whatever's going to happen. So we'll pick that up. But I had something come up a few days ago that is interfering with this calendar that I need to go deal with. When I get back, I think it's the only thing left. Is that correct?
Correct.
Okay, all right. Then I will be back as soon as I can be back. You all are safe to be gone for a half hour if you want to get some food and just be back. And we'll start as close to 2:30 as I can make it, but I don't really control how long I'm going to be away. Okay, but we'll definitely get to this. This remains a stipulated to but non-negotiated revocation, or I don't know that the state has witnesses here. Okay.
The state doesn't, it's a stipulation. Yes, a non-negotiable.
Okay, that's what I thought. I mean, just based on what the allegations are, that's what I had heard is that it is. Okay. Anything else? No? All right. I'll be back as soon as I can. Thank you.
Want to sleep in your bed? Cool.
Bye, Holly. I'll see you later. I don't see them. Where they at?
Podium, DFD, wrong. You gonna let him go all the way across, you stupid bitch. Two 30, I've been my hair. 2:33. I'm frozen. From a good family, he was raised in a two-parent household, as we all were. Please ask to give him a second chance. As far as John, Chris Jones, he's a guy. He believes in God. Looks like Terry there.
Oh, you're very welcome. Bye. You too.
Hey.
Gotta get better at shade.
Shade?
Yeah, I'm not good at finding shade. 'cause
Oh.
I forget.
Me, I
I live in
am.
Florida now.
I am definitely good at finding shade everywhere. I know I've been complaining about being cold. I'm like, oh, I can't wait to get bit by a
Ma'am,
mosquito.
ma'am,
Oh,
please mute your device.
oh, I'm sorry. I thought I muted it. How do I do it? I don't know how to mute it. How do I mute it?
Can we get more funding?
We asked for funding based on growth because there were accountability court participation growth. It was 11% higher 2 years ago, 12% higher last year. So we're at higher than pre-COVID levels. And with that growth, it costs more. So we asked for a little budget growth. The main thing is that the governor had allocated a bunch of the opioid abuse settlement funds to pay for the council, which would make sense, like, hey, that's related to drug treatment. But the settlement agreement is very, very restrictive in how the money can be spent, and it can only be used on people with opiate addictions. And that's less than 10% of the drug court population. But they wanted to make 2/3 of the budget through that. And that would leave all the opiate addicts could get Cadillacs from drug court and everyone else would have to quit.
Quick question.
Yeah.
Harrison, on the 20th, do you want the defendant transported, or is that gonna just be the attorneys? It's that conference.
Oh, just the attorneys. That's just to make sure they're ready to go.
Okay, that's
and
what I.
keep them focused.
Okay.
Yep.
Thank you.
Hi, Ms. Fisher. You still with us?
I am, Judge.
Great. Thanks for your patience. Sorry for this delay. Ms. Wood, are you ready for me to have, are you ready for Mr. Leak to come out?
Yes.
Okay. Deputy Gordon, are you ready? I saw you stretching there. All right. All right. Let's get on the record. This is 25 SC 007092, State versus Broderick. Leak. Hello, Mr. Leak.
How you doing?
I'm unhappy to be seeing you dressed like that so soon after I last saw you, but here we are. Mr. Leak is in court with his lawyer, Ms. Wood. We have Ms. Potter here from the District Attorney's Office. We're here, Mr. Leak, because in December of last year, so just a little less than 2 months ago, I signed a probation warrant that alleges that you got arrested for a new felony offense in Clayton County, possession of drugs and driving a vehicle on a suspended or revoked registration. That second one's a misdemeanor. The drugs are a felony. Either way, you got arrested for something and you had fairly recently been put on probation. So we need to work through what the consequences are. You have 6 years and almost 9 months remaining on your probation, so a bunch left. And as I understand it, your charges in Clayton County are still there. They have not been indicted yet, but they're out there. I'm going to let Ms. Wood talk to me a little bit about the situation and make her recommendation. I'll hear from Ms. Potter, who is the prosecutor for the state on this one, and then I may even have some questions for Ms. Simpson, and we'll figure out what's going to happen, okay? All right, Ms. Wood?
Thank you, Judge. So Mr. Leak is admitting to the arrest only. For the Clayton County case, he has advised me that he does maintain his innocence. There was a passenger in the car.
Mr. Leak was the driver. Got it. So the driving with a suspended license, he didn't need to admit anything, but the passenger ain't gonna own that in the end.
Yes, Judge, I understand.
Okay.
It's important for Mr. Leak to share it with you or through me.
Yes.
That his passenger is claiming the felony amount of drugs.
And what was it?
Marijuana?
Yeah, 2 ounces of marijuana.
Okay.
So I wanted to share that with you, Judge, at Mr. Leak's request. He has been working since we last saw you, which was a very short time ago. He just had a newborn who is here in the hallway. He has other children that he is taking care of. He has tremendous family support, as you have seen today, Judge. He has been in continuous custody since he got arrested in early December. So we are asking for the court to consider revoking 6 months, and then of course he would get the credit with the idea that he get the credit for the 2 months he's been in. We would ask that he be reinstated to probation and to retain first offender status.
Who was the passenger in the car? And I don't need names, but it's the young lady with red hair?
Yes,
Okay.
sir.
Who is that to you?
My girlfriend.
That's your girlfriend. Okay. And you're saying it was your marijuana?
Yeah.
Okay. Have you told Clayton County that? And what are they doing? Nothing. Okay. How much is 2 ounces? Is that like a garbage bag or?
56 grams.
But
In a small Ziploc bag.
Okay, if you were to hand me 2 ounces of marijuana, you don't need a wheelbarrow to do that. Like a little plastic bag or like one of those little dime bags?
A little sandwich bag.
Little sandwich bag. Okay, all right. Interesting. Okay. Ms. Potter.
Yes, Judge. The state echoes the same concern about his arrest about a month after he had been sentenced. I also have notes here that the state null-crossed a couple of the counts and also reduced it to cruelty in the second, so he could plead a first offender. Since the case hasn't been indicted and it is marijuana, there are worse charges. The state's gonna recommend a year to revoke, which is consistent with probation. And just warn Mr. Leak that being around criminals or being around criminal activity is just as bad.
Okay, and does that recommendation include maintaining the first offender? And that's the warning?
Yes, Judge.
Okay.
Keep his first offender and then just revoke a year.
Okay, so what you're saying is, well, I can answer this. Let me look.
Maybe he's been in 60 to 90 days.
So it's an accusation. So there was an indictment, a 24 SC, and then through negotiations, Ms. Williams or one of your colleagues said, all right, you know what, we'll do an accusation. What were the original charges such that it had to be reaccused so he could do first offender?
Child molestation.
Oh, okay.
And then that got on to a cruelty in the second, which carries a sentence of up to 10 years.
Right, and doesn't require any registration or anything like that.
Correct.
Okay, all right. Ms. Simpson, couple questions for you. One, what is probation's perspective as to what to do with this? And two, were there other issues during the very, very brief time Mr. Leak was on probation?
Judge, my recommendation was to revoke a year based on the fact that he was arrested almost exactly 30 days after his plea. In regards to his short supervision, he made it as far as he did complete his initial report. He hadn't had any issues up until he committed this offense.
Okay, got it. Ms. Wood, tell me, Mr. Leak had, well, sorry if I asked your client, it's not about the case, it's about his family.
Yes, Judge.
Mr. Leak,
Yes, sir.
you have kids?
Yes, sir.
How many kids?
8.
8 kids. This is starting to come back to me now. How many of them stay with you?
2.
2, okay? And your household these days is you plus 2 kids plus the young lady with red hair?
Yes.
Just the 4 of you?
Yes, sir.
And those 2 kids who stay there, how old are they?
9 and 2.
9 and 2. Your other 6 kids, are they all older than 9?
11, a 9-year-old, 3 8-year-old, and a newborn.
A newborn?
They came out January 13th.
Huh, okay. From someone who's not in the room right now. The mother is someone who's not in, is right there. Someone sitting next to your girlfriend is the mother of the newborn.
Yes.
Got it. Okay. But that little boy or little girl?
Little boy.
Little boy stays with that woman, not with you.
Yeah, I haven't even seen him yet.
Okay, I guess you've been locked up. You couldn't have.
Yeah.
Got it. Well, congratulations on number 8.
Thank you.
And then you've got 3 who are 8 years old. Are they triplets or it's just
There's twin daughters.
twin daughters? Okay. All right. What's the last name of the young lady with red hair?
Stowers.
Does Miss Stowers work?
Yes.
What does she do?
Work at the airport.
Okay. What does she do? Is she a pilot? Does she cook at one of the restaurants at the airport? Okay. And then the young lady sitting next to Miss Stowers who just had a kid. Was she working before she had the kid? Do you know?
Yes.
Okay. Doing what?
What? A bus monitor. A bus monitor for APS schools.
Okay.
Yes, sir.
Does that mean you sit on the bus and make sure kids behave?
I deal with disability kids,
Getting people out to the bus.
yeah, so I help the driver with like disabled kids and Down syndrome.
Got it. Get onto the bus or off the bus. Okay, thank you. All right. Anything you want to add, Mr. Leak, to this situation?
Yes, sir.
What's that?
The day I got arrested, I actually had Miss Stowers' car when I actually went to work, and I worked from 6 to 7 p.m. So when I got home, I didn't have any knowledge that marijuana was in my car at the time. I went to the store when I got pulled up. I didn't know it was in my car because I was at work for 13 hours. So it's impossible for me to know that marijuana is in my car. I don't smoke. I don't drink. I took my drug test and intake. I passed it.
So I thought you had someone in the car with you.
Yeah, she was in the car with me.
Okay. You drove to work?
No, I drove her car to work.
You drove her car to work?
2 different cars.
Right.
She had my car that day.
Right.
And I had her car. Yeah.
So you're at work with her car?
Yes.
And then you're driving home from work in her car?
Yes.
And that's when you get stopped?
No, I got home at 7:30.
Huh?
I spoke to my probation officer briefly, 5 minutes on Zoom.
Huh?
When I left the house to get something to drink from the gas station, that's when I got pulled over into my neighborhood.
And Miss Stowers was in the car with you
yes.
to go get something to drink?
Yes, sir.
Got it. Okay. And
I don't smoke because I had my dog do random drug tests, so I don't smoke at all.
Okay.
And I coach a baseball team.
What age group do you coach?
It was 9-10, but we're going to 11-12 this year.
Okay. Where?
I'm trying to go to Jonesboro Park. I was just at Riverdale Park.
Okay. Well, Mr. Leak, this is frustrating and unfortunate. I'm hearing what you're saying, and it may well be that the situation in Clayton County ends up being not so problematic. They're going to need to work that out, and it sounds like Ms. Stowers is willing to come forward and say what she's going to say to the authorities in Clayton County. I've got someone who got a whole bunch of breaks to get the outcome that you got, where it was first offender probation based on originally what it was a charge of child molestation. And that's not me saying that was the right charge to begin with, but it was the charge to begin with. And because of the advocacy of your lawyer and you apparently not being a super terrible guy, you had no criminal history because you got first offender. That was reduced all the way down to cruelty in the second. And you got this opportunity. And that's what I want to emphasize is that is an opportunity. And you kind of crapped on it. If you didn't have a DL, you shouldn't be driving.
No, I do have a driver's license.
So what was the driving on this?
She said I had suspended registration.
Oh, so it was for the car.
Yeah, and I pay my insurance. Yeah, I pay
again.
my insurance every month. She said it's from May, but it's like I pay my insurance every month. So I'm trying to figure out how was it suspended.
But registration has to do with the car and not the driver's license. Be that as it may, you got to be extra careful in the way you're telling me you're careful. Hey, at my job, they test me so I don't smoke. The people who care about you and you care about need to say, hey, don't get in this car today. You should drive your car. And that can just be their code of saying, man, this car's hot. Don't ride in it today. And you're like, straight, I'll drive a different car. But you got to be that careful. And life is complicated. You got 8 million kids and you're trying to take care of them and you're pulled in lots of directions. You just have this burden of being extra careful in a way that maybe someone else doesn't need to do, because if they were to say, oh, I'm surprised by this, someone's going to say, you already got your break and you don't get a second break. I will leave your first offender intact, but I like the word that Ms. Potter used, which is this is a warning. You just can't get arrested again because that's not what someone on first offender does. If the speed limit's 55, drive 54. And that's boring, and your kids are going to say, "Oh, Dad, you're such an old timer." But you know what? You're going to be an old timer on the outside of the jail and not on the inside of the jail. So drive 54. And if you're getting into a car and you can smell what was in that car and say, "This is cool, man. I'm going to call an Uber."
I actually didn't. She had it in the trunk. So
Okay. You know what? I don't care if she had it inside the wheel. It was in the car and you can't, it's the same deal with guns.
Yes, sir.
I'm not saying you got caught with a gun, but if you got a roommate and your roommate's a gun nut and has a bunch of guns, that can't be your roommate anymore. The things that other people do close to you are going to have an impact on you. And if they care about you, they're going to just let you know, you shouldn't ride in my car today because I have hidden in the trunk, whatever it is. I'm not saying it was out and open or it was a 2-ounce blunt that was right there, but it was in the car. And so it's a lesson for your community, the people you work with and spend time with, is that they got to be careful around you. And if they're doing something that could get you sideways with the law, they should let you know and say, "Nah, come over tomorrow, not today," because it's going to blow back on you. And you got a lot riding on this first offender situation. All right. I'm going to revoke 9 months of your probation. And reinstate the balance. You will not have your first offender taken away. When you get out, you're going to be as you were. You need to plug back in with probation, and you need to make sure that when you move forward, you do it in a careful way so that you don't bump into a situation like this, because this is sort of your second chance as a first offender, okay?
Yes, sir.
All right. Ms. Wood, anything else?
No, thank you.
Ms. Potter? Thank you for filling in. And for friends and family of Mr. Leak, I appreciate your patience today. I know you scrambled to get here and then I disappeared on you all. That wasn't intentional. I just had this thing come up that I had to deal with. Mr. Leak, I'm cautiously optimistic that you're going to navigate this differently in the future.
I am.
You are a family guy, at least you create a very large family. And so I'm hopeful that you'll want to be there for the brand new one and the 2 that you have with Ms. Stowers and et cetera, et cetera. So
Yes, sir.
I hope you do better next time, okay?
Yes, sir.
All right.
Thank you.
Ms. Fisher, that is the end of our court today that requires takedown. We've got one session a little bit later to talk about some other stuff, but 1, it was great having a reunion with you, and 2, I very much appreciate you parachuting in on short notice. Karen Rivers, the court reporter I have the fortune of working with, graciously agreed to cover a day of trial for a judge where we need in-person takedown and we're struggling to line something up.
Yeah, I knew that. Yeah, well, very good. I was happy to do it anytime.
All right, and thank you for calling it out when we were straying from the microphones too. That's important.
Yeah, sure thing. Thank you. I appreciate you being patient with that.
Nope, all good. Take care.
All right, you too. Bye-bye.
Bye-bye.